by back to mention item number 12, Lordship. Just in the other side, Lordship. Lordship, may I pray, Lordship, maybe adjourn for 2 weeks, Lordship.
Can I have it listed after the vacation?
Lordship.
Because all these matters are now coming
My
out just before the vacation.
My
It will
Lord.
be again a chaos.
Lordship.
Item number?
12, Lordship. I am for the department, Lordship. I have taken consent of the other side.
Okay, item 12. List immediately. Give a date after the opening. The list on Spencer is paid for by Mr. S. Chedial and Standing Council for the Income Tax Department.
Deeply obliged.
Okay, we'll give a date.
Lordship.
Okay.
May I please, sir,
Hmm.
this is serial number 6766, public 2013.
Here listing, give it to the court master. You have to make some adjustments here or there.
Sir, kindly,
I am not giving a fixed date. The court master will have to make an adjustment. Every day we have more than 60, 70 cases. I can't handle it.
some urgency of this.
I can't help it. There's no point listing a matter and then not taking it up. I am not giving a fixed date. I am not giving a fixed date. Let the court master decide. I'll not give a fixed date. It will be the court master's discussion to decide because he'll have to go through the list and then find out. I'm not giving a fixed date.
Please, sir, that's it. Item part 2, item 15. My senior is not present. So it may be taken after 1 week
Okay.
if your pleasure.
I beg to mention 2 items, Your Lordship. This is the eviction matter, Your Lordship. Tomorrow, probably, Your Lordship, eviction will be carried out. Therefore, may I pray for listing of these matters tomorrow, Your Lordship.
May I please, Your Lordship. I beg to mention item number 13, Lordship. On behalf of P. Sharma, standing Council AFDC, a consent for the address petition I already taken, Lordship. I pray for adjourn for the day, Lordship.
Okay. Pass over the day is paid for by the council for the EFDC.
Master.
May I please, I beg to mention item number 14, Lordship. We are appealing for respondent 5 and 6, Lordship. Just, we have entered appearance by filing Uttara Lordship. We need 2 weeks time for.
You've taken consent?
Yes, Lordship.
Lordship,
There is a
I have no
interim.
problem, but interim that is not taken, Lordship.
Okay. What is this matter?
Matter is, my lord, eviction, demolition of building, Lordship. My lord, that is Miadipatta land, Lordship. We have to demolish. So.
Okay,
I have been
list
protected.
after the ensuing, immediately after the ensuing, summer vacation. So the interim order passed a distance extended till the next day for this time. This say, matter adjourned on the prayer made by land council for respondent number
5 and 6.
5 and 6. We're listing it after vacation. Yes.
Please, Your Lordship. Lordship, I beg to mention item number 5, the engaged counsel, Mr. D. Who is out of station. The matter may be adjourned for the day.
You've taken consent of the other
Yes,
side?
Your Lordship. Consent has been taken.
Okay. Any interim order is there?
I am appearing in this for the petition.
Interim order is there?
No interim order, but the matter is some monetary need to next Thursday, Lordship, if possible.
Not on Thursday. Let it be Friday.
Hearing,
Friday,
some
16.
hearing part is
It's okay, but I have some pattern matters. List on 16/6/2026 as paid for by land council for the forest department. Okay.
Lordship, I have a similar prayer for item number 6, as we are still awaiting instructions. Matter may be adjourned.
Taken consent of the other side?
I am for the petition, my lord, kindly see that 2/4/2022, this matter was listed for and directed them to file affidavit, my lord. And my lord, they have taken also time there. My lord, there is a, my lord, matter where, my lord, my stone crusher machine has been closed down, my lord. They are showing no any indulgence matter, they are filing affidavit, no any.
Okay. A prayer for adjournment is made on behalf of Standing Council for Forest Department. Mr. S. Chamadel and counsel for the petitioner has objection to the adjournment on the ground that the stone crusher of the petitioner has been closed. First up, it is made clear that if the affidavit in opposition is not filed within a week, the prayer for interim relief made by the petitioner shall be considered.
deeply.
List on, give a date, fixed date next week.
Lordship, can it be 10 days?
10 days.
Yes.
Okay, give 10 days. 21/6.
My lord, deeply.
And your blood sugar.
May please your lordship.
Speaker to converse.
Yes,
Yes,
please your lordship. The engaged counsel for the respondent number 4 in item number 1 is indisposed today. Lordship, the matter may kindly be adjourned. 2 weeks. Number 4.
just. Respondent 4 is not required to be heard. Who is for the government? Yes. Yes, sir.
I am for unit of the railway.
You are in the matter. What is the difficulty in having a demarcation done? Why the Union of India has to come to this court?
For demarcation of railway land management. Allotted to the railway in the year 1985.
We'll dispose it of it, direct the authorities to do it in a time-bound manner.
Yes. Lordship. Respondent number 4 has to file an executive appeal.
You don't have to file it. What will you say?
The last order.
You have objection to demarcation. What sort of objection you can make?
I've been informed by the engaged counsel that.
No. We are not adjourning it. Unnecessary, the matter for, whatever you have, you will raise it before the authorities who are doing the demarcation. We'll permit you that. But why an application for demarcation will be kept pending? It's a railway land, they want to find out whether it's a railway land or not. It's in public interest. Your private interest will have to, the public interest will prevail over your private interest. If it is your pata land, you will not be disturbed. And this A guy and then CEC appearing for the petitioners.
Item number 1, my lord, A.
Just one by one. This is. Item number 1 is Mr. A. Dasgupta, senior counsel,
Yes, ma'am.
but he's not there.
My lord, he was there. I may be allowed to call him, and he was.
He was
yes,
there,
yes,
okay.
ma'am. I may be allowed to call
No,
him.
it's okay. If you say that he was there, take it from me. A. Dasgupta, senior counsel, assisted by Mr. S. Chakraborty, counsel for the petitioner. The second case is about same.
Can is my lord contempt? I have filed item number 2 and 3 is the contempt, my lord. That
So
may
we'll
be
pass
good.
separate orders. This two repetitions take up together. Item 1 as well as item number 4. This will be number 1, huh? In WBC 1838, You see Mr. Dasgupta with Mr. Chakravarti. And in item 4, WBC 1907 of 2022, they say that none appears on call for the petitioners. Also heard Mr. S. Barwar and a government advocate appearing for respondent numbers 2 and 3 in WBC 1838 of 2022. And Ms. G. Hazarika done with government Standing Counsel for Revenue Department appearing for respondent of one decided petition. And in this second petition, you say the same 2 and 3 in both the petitions. 2, 3, and 4 in second petition, Mr. Barwa and Ms. Hazarika for number 1, and Ms. Egan CEC for respondent number 6. Next, the Learned Counsel for respondent number 4 in WBC 1838 of 2022, and respondent number 5, who is the respondent number 5 in WBC 1907 of 2022. Your name?
Emma Sharma. On
Mr.
behalf
Emma,
of Mr.
Mr. Emma Sharma, appearing on behalf of Mr.
K. Singh.
K. Sinha, counsel for respondent, said respondent, has paid for an adjournment on the ground that the learned counsel is indisposed. Full stop. In view of the nature of order proposed to be passed, the prayer for adjournment from the private respondent is not entertained. Next paragraph. In just give a heading, facts in the WBC 1838 of 2022. The Union of India, representing the railways, has projected that the NF Railway had acquired about 502 bigha 4 Katha 2 Lecha land in Maligaon and Bhatanagar area under Ram Sarani SARANI Moja, which is presently Jalukbari Moja in the district of Kamrup in the year 1958 by virtue of notifications, land acquisition notifications dated 21/6/1958 and 25/6/1958. It is projected that the railway authorities were provided advanced possession of the said land. And in respect of such acquisition, the railways had also deposited the estimated land acquisition compensation of rupees 11,53,912.06 by check dated 25/9/1959. Full stop. It is also projected that as per mutual agreement between the railway authorities and the government of Assam, the portion of land was handed over to the state government for construction of Pandu Port. And in lieu, the government of Assam had given to the NF Railway about 45 bigha 0 Katha 14 Lecha land at revenue village Gotanagar under Ramsarini Moja within bracket Jalukbari Moja, presently Jalukbari Moja. And in this regard, a land acquisition notification dated 3/8/1963 was issued by the state government for acquisition of the said land. First, it is projected that the railways are in actual physical possession of the said land. First, the NF Railways has approached this court by filing this writ petition on the ground that the railway administration has been constantly requesting the Deputy Commissioner, Kamrup Metro, for initiating steps for demarcation and identification of the railway land measuring 45 biga 14 decha, 0.14 decha in revenue village Bhotanagar and Maligaon. Post of Hava. The grievance of the railways is that the concerned district administration have not taken any steps for demarcation of the boundary. Stop. The NF Railway expresses their concern as unauthorized, they are part of their land is under unauthorized occupation and illegal constructions have been coming up. Post it is submitted that as if due to lack of demarcation, the railway authorities have not been able to take steps for clearing the lands from encroachment.
Lordship. In this respect, the recent affidavit which has been filed by the circle officer. So here the details have been given as regard the land reside in possession of the railway and on the basis of the survey. So for that matter, may I take your lordship to that last affidavit that the circle officer has prepared? So
That is filed on
Yes,
what you call
the
date is not there.
3rd of April 2023. 3rd of April.
3rd of April.
Yes. Correct.
3rd of April. Yes, got it.
So running page 25.
paragraph 5 onwards.
As your lordship got
Yes.
this page 3, the last part, may I go into the detail of it? It is further stated that the assistant director of survey, so and so that it has submitted the survey report along with comparative map prepared in this regard after completion of survey / demarcation over the plot of land covered by dark number so and so under the jurisdiction of this office. After going through the survey map submitted by the Assam survey, it is seen that the part of land covered by dark number 542 new and land recorded in dark number 551 of Bhotanagar under Moja Jalupuri has been claimed by the railway as per acquisition record. After field verification by the LR staff, it is seen that the land covered by 542 old and so is not under possession of the railway department Sita enclosed. Again, as per the award leased in respect of the acquisition of railway land, the land covered by dark number 542, 551 old is acquired railway land.
You see, Mr. Barwa,
Yes.
you see, in a demarcation case, when they do the demarcation, whatever is found,
Whether it is in the possession or.
they will just put the pillars.
Yes.
It may be in their position, it may not be in their position. But if the authorities feel that in demarcation, this is the land which is allocated to them as per the land acquisition case, they just try to put pillars and demarcate and give it to. There's nothing more to be done.
With the exercise.
Only that exercise has to be done. After that, if any land is left out, not acquired, then the railway will do the take steps because we are not entering into the dispute, deciding our right title and interest.
Yes.
What we are concerned is we have to protect the interests of respondent of 5 also.
That's true.
The petitioners in the second petition also, that they are not evicted without due process of law. So if there is if after the demarcation, it is found that X or Y is has imposed the government, the railway land, then law will take its own course.
Yeah. In fact, here parawise the breakup has been made as regard the dark visa in acquired railway land as per the award. So these details has been given, but for that matter, again, the demarcation exercise has to be carried out.
They have done the demarcation. There, you see, this map is there at page 46, 45. Page 45. This map is there.
Yes.
This one plot which is claimed by them. Correct. Now, other pataland claim possessed by the railway, and the red marking is the position in the hand of railways. So, what is the exercise to be done is that it is your land acquisition, the government's land acquisition notification. They'll have to just demarcate and say that this was the land which has been there.
There.
Now, who is in possession, who is not in possession is not the concern of that.
Yes.
all the authorities. They have to just demarcate the land which was given to them in lieu of this land. Only that much access will be done. Now, whether it is lawful, whether it is unlawful, that is the second.
second part.
Second part. That is why I'm not adjourning the matter, because unnecessarily this has been kept pending.
Yes.
Only the exercise required is that you will put the what you call the
pillars.
locations, and those locations, now we have those GPS and all those things, but I don't know the term. What is it called geolocation.
Imagery.
Geolocations can be forwarded, and then the law will take its own course.
Yeah.
If it is a patta and not acquired, then they are saved. Because we can't, we'll have to protect the private interest of the private process also. They will not be evicted without due process of, and this is not an eviction process at all.
Yes, ma'am.
Just add the next para. In this regard, the learned government advocate has referred to the additional affidavit filed by the respondent number 3, i.e. the circle officer, Guwahati Revenue Circle, which not only contains the brief, the detailed description of the status of land which was surveyed, but the said affidavit also contains map showing status of the land as per acquisition by railway on the map of 1962-63, which indicates boundaries of land claimed by the railways as per acquisition public record, comma, this will be number 1. Number 2, other patta land claimed to be in possession by the railway, comma, number 3, land possessed by the railways. Full stop. It would be appropriate to quote paragraph 5 of the said affidavit, which gives the detailed description of the land surveyed. Now, second heading will be facts of WPC 1907 of 2022. This they said WPC 1907 of 2022 has been filed by 11 petitioners. Stop. In brief, the case of the petitioners is that when land acquisition notification dated 23/8/1963, which was published in the Gazette on 28/8/1963, 45 bigha 0 kata 14 acres land was acquired by the government of Assam for providing land to the railways in exchange of land given to them for Pandu Port. The petitioners claim that as per the notification, in the south portion, the acquired land is covered by DAG number 550 of the it will be there in this flag. I'm not saying it. pink flag. Next paragraph. This is Mark 1. Next paragraph. The petitioners claim that in the year 1966, the revenue authorities had prepared a trace map for the revenue village Kotanagar. And in this said map, the DAG number 338 is situated in the east of DAG number 337 and also DAG number 337 and that DAG number 337 is situated in the east side of DAG number 336. It is also projected that now I have marked there page serial number 2. This will be there. Next paragraph.
Right.
Please the next part. Next paragraph. Serial number 3 here in this page. Next paragraph. Accordingly, the petitioners claim that several representations were submitted to the concerned authorities to correct the anomalies which has been caused by the shifting of the position of the concerned DAG. Number 549/332. Accordingly, it is claimed that the private respondent 5, namely Sri Jagannath Kumar, JGNN8H Kumar, has been digging earth to start construction over the land, and the petitioners apprehend that they are 8 feet land, which is for ingress and outgress to their residence, would be usurped in making construction. Next, in their affidavit in opposition, the railway, the NF Railway has taken the following stand. Has amongst others, taken the following stand. Page 117. Para D. Therefore, the respondent the NFRB claims that the private respondent is an encroacher on the government land. The circle officer. Guwahati Revenue Circle, within bracket respond number 3. In his affidavit in opposition filed on 1/8/2022, has taken the following stand, paragraph 17, page 91. 92. Mr. Barwa.
Yes.
Can you just read this para 17 and try to because I have not read it completely. Para 17, page 6 of your affidavit. I'm just trying to understand what he's trying to say. I have not read it. Huh? I'm not applying my mind.
Yes, sir. And
I thought that since you are there, I may not take the trouble.
okay, sir. So what it goes to, so that during field verification, it has been found that an RCC construction is going on over tag number 317, which is the land of the respondent number 5. And that apart, there is a road of 8 feet running beside the tag of 317. And for during field, the measurement of it is seen that no portion of land recorded in the name of the petitioner is included in the land of Jagannath Kumar and other patadas recorded in DAG number 317. So 317 Jagannath Kumar is respondent 5.
Okay. So his land is, as per the circle officer, his land is his own.
Yes.
It's
My
not the
lord, that
petition.
has been contradicted by the subsequent affidavit filed in 183. Lordship may have a look at the affidavit that was filed on 3rd of April. I'm just drawing your lordship's attention to that.
Which affidavit?
Affidavit of the additional affidavit filed in 1838, 3rd of April. By the circle officer.
Just a moment. Just a moment.
Lordship may come to page number 27.
Additional affidavit.
Yes, page number 27. Roman 7.
Yes.
Furthermore, as mentioned in the survey map, land record in tag number 549 old, 317 new, measuring 49.22 R is also claimed by the railway as per acquisition report. During field verification by the LR staff, it is seen that the construction of an RCC building is going on the land covered by tag number 317 new, and possession of railway land has not been seen in respect of tag number 317 new. Again, as per the award list regarding acquisition of railway land measuring 49.22 are covered by tag number 549 old, 317 new is acquired railway land.
No. You see, it is clear. Their affidavit is very clear.
Very-
You come to this paragraph.
Page 4, last but one paragraph.
He's explained that. There's
Well,
one part of land was remaining,
Yeah.
and that part of the land, even the petitioner claims that part of the land was sold by the vendor. One part of the land was acquired, and one part of the land was sold by that vendor to the to private
If
persons.
your lordship goes to the earlier affidavit, they are showing that present DUG number 317 has come from a different DUG number. Here it is says that the old DUG number of 317 is 549, which is a railway acquired land. So in
Not the
the,
entire land,
yes,
not the entire land,
my lord,
not the entire land. Not the entire land.
not the
The-
entire land,
the
but
private-
not the entire land he is under
Let me tell
occupation.
you what is happening. The petitioners in the second petition, they are claiming that there was a part of land which was left out.
Yes.
And one part of the land was acquired, one part was left out. Out of the left out part, one part was sold.
So
And that is the contention or dispute between the parties
In the second writ petition,
in the second writ petition. So in the writ petition, the first writ petition, you may have a claim
yes.
for that time.
Yeah.
So that is why we are saying, you see, that is what we are wanting, that there should be a demarcation made.
As per the 1963
Whatever
acquisition,
they'll do it as per their.
Existing.
my lord, as per the acquisition of 1963, by which that 45 bigger was given. And my lord will also please to observe that any construction in that present 313 shall be subject to outcome of that.
No. Because that is his writ petition. A private petitioner's writ petition. In your writ petition, it's not that, that's not the prayer, it's
That
only
is
for
not the-
demarcation.
Yes,
After that, whatever you do is your lookout.
because there is,
I'm not putting in
That
words
will
which is not
exceed
there.
beyond what is free.
because my lord, if that land is ultimately decided that it is a railway acquired land, then my lord, there will be a difference.
No, you see, Mr. Chakravarti. I'll always have respect for the learned counsel. You will be there to brief them. Why should I put words which are not required?
Because there is already an interim order, any construction shall be subject to outcome of the writ petition.
But it's not
So
in
finally-
consonance with the,
Yes,
in the substantive prayer.
Yes.
My lord, there was a combined order passed in both the writ petition.
This I'll not do. For a simple reason, I'll refrain from doing it. The reason is very simple. This is a writ petition. I'm not taking up, I'm not a, what you call, what you call a trial court to decide
Yes, ma'am.
these issues. So I'm not going to give any sort of protection, save and except directing the demarcation be made. And if you get if you acquire if you have the right, then you'll do in accordance with law. That will permit. Whatever you do will be in accordance with law.
Because my lord, when both the petitions were heard, respondent number 5 filed an application interim IA praying for an order that his construction may be carried on. Then an order was passed by this honorable court saying that he will be at liberty to carry out the construction, but any construction shall be subject to outcome. of
Okay,
the-
see that, let me finish, we'll come to it. Let me complete the.
Your phone. Please,
Next part.
you can enter voting. Yeah, just.
Having noted the contours of the contents of the both the writ petitions. First of all, the bone of contention of the railway authorities is to the extent that the land measuring 45 bighas, 0 katha, 14 lechas, which was acquired in village Gotanagar and Maligaon under Ram Sarani Moja, within bracket presently Jalugwari Moja, was acquired and handed over to the petitioner to the NF Railways in lieu of and oblique or exchange of land handed over to the state for Pandu Port. And in this regard, the railway authorities are relying on the notification dated, land acquisition notification dated 3/8/1963. Just write notification number RLA /86/63/16 dated 3/8/1963, which is stated to have been published in the official gazette. First of all, the court has taken note of the additional affidavit filed by the circle officer, within bracket respondent number 3, in the proceedings of WPC 1838 of 2022, which is already narrated above.
See that.
Mr. The in this regard, the court finds that the prayer made in WPC 1838 of 2022 is only for a direction to the respondent authorities to carry out the process of identification and demarcation of railway land measuring 45 biga 0 14 lechas in Maligaon and Gotanagar village. Is Maligaon or Gotanagar? Which?
Total.
Somewhere you are saying Maligaon, somewhere you are saying Gotanagar, somewhere you are saying both.
Lordship,
45 biga, my lord, it is.
here she is appearing on behalf of respondent 5. She wants to add up that as per her information, already the demarcation exercise has been carried out. That is her contention. Has no knowledge as regard.
Lordship, as of now, I've received instruction from the council who is engaged. He is not well at all, Lordship. He has said that already a demarcation process has already been done and which has not been brought forth by the
It's
Other
okay, if
party.
not done, they will do it because we'll more rely on the government than a private respondent to leave it midway. It's a railway land is a public property. So therefore, it must be brought to a logical conclusion. We are not depending on your own statement because you are an interested party, but we'll see that the authorities, they complete the process and then to the satisfaction of all concerned. Not satisfaction, I'll say, which can be observed by the all parties concerned. The pillars would be put, whether it is in your land or land of X or Y or Z, that will be subject matter of separate adjudication. Yes, what you are trying
My
to
lord,
say?
this 45 bigger and revenue village Kotanagar and Maligaon, some in Kotanagar and some in Maligaon.
No, that can't be because then there will be notification will say separately. If it is two different villages, then the notification will give description of two villages. It not be one. It can't be so and so or so and so.
Lordship may come to page 19 of the writ petition.
Page 19.
Of the writ petition. Whereas it appears to the government of Assam that land is required to be taken by the government at the public expense for public purpose, based for providing land to the railways in exchange of the land given by them for Pandu Port in the village of Bhutanagar and
Maligaon, correct?
Ramusarani Moja. Ramru.
And this is only a declaration. Then after that, where is the notification?
That notification is not available with the village government. That will be there with the state authority.
Then, Mr. Secretary, this will go against you. Then we can't order demarcation unless the land is acquired.
My lord, the
Section 6
fact the
notification-
land is acquired is admitted in the affidavit, my lord. They have admitted that the second, that is the additional affidavit says the land has been acquired, my lord. In paragraph 5, my lord, the old Doug numbers are given and the corresponding new Doug numbers are given, against which they have stated that this is acquired railway land. It is,
Where you are reading?
my lord, may come to the additional affidavit of the respondent, number 3, the circle officer. So from paragraph 5.
Just a moment.
Roman
Just a moment, just a moment. Additional affidavit.
Yes, yes. That may come to page 26, Roman 3. Last 3 lines. Again, as per award list, in respect of acquisition of railway land, the land covered by that number 542, 551 old is acquired railway land. So again, in paragraph 4, 543 is acquired railway land. Then 5, acquired railway land. Then 7, my lord.
No, merely because of by saying that we can't give a declaration. The High Court will not give a declaration without the land. What do you call the land acquisition itself having come on record. You have the Jamabandi of the said land. Have you filed any land records? Because even if you can produce a Jamabandi, it will contain that the land has been acquired and it has been it is shown as a railway map, railway land.
The additional affidavit also gives the picture, shows that map showing status of land as per acquisition by railway on the map of 1962-66.
No, then you have to get ready for the second round of litigation because then make a qualified order. This is subject to what you call verification of the authorities of land actually being acquired. Because the authorities in their what you call in their notes have or in any of the documents, they have not reflected the land acquisition notification.
Jamabandi to land.
What is the last statement I made? Action. Process of demarcation. Okay. Uh, First, uh, it may be mentioned, next one, it may be mentioned that as per the stand taken in the red petition, comma, wide notification number RLA/86/63/16 dated 3/8/1963 comma, we 45 because 0 acres of land was acquired. However, on a perusal of the said notification, it appears that it is that the said notification is in respect of declaration made under section 6 of the Land Acquisition Act. Although stand is taken in the additional affidavit filed by the respondent number 3 that the land was acquired for the railways. But the learned counsel for the petitioner and the learned government advocate have not been able to show the notification for acquisition. Therefore, comma. Next time, therefore, comma. The next paragraph, therefore, comma. As railway land is a public property, comma, the land and revenue personnel under the establishment of the Deputy Commissioner, Kanpur Metro Guwahati, are required to conclude the demarcation process, comma, which has been initiated, as can be cut out from the additional affidavit filed by respondent number 3, i.e. the circle officer, part of the unit circle. Its logical conclusion by setting up the demarcation pillars. First of all. Next paragraph. In as first of all, nonetheless, comma, while doing so, comma, the land revenue authorities under the establishment of Deputy Commissioner, Kanpur Metro Guwahati, will have to take into consideration the land acquisition notification that may have been issued
So if I may be excused.
Yes, yes. Okay, just recast that word. Section 6 is the declaration. No other declaration is required. The authorities will have to take into consideration the declaration. Issued under section 6 of the Land Acquisition Act. And the demarcation is required to be done in respect of, in consonance with such demarcation. Next paragraph. Insofar as the insofar as the proceedings of WBC 1907 of 2022 is concerned. The petitioners therein claim that the land covered by DAG number 338/552/317 has been shifted from its original position by claiming that the shifting was from south to eastern side of DAG number 459/332 and a part of DAG number 550/336. System. In this regard, the concerned personnel undertaking the demarcation of the railway land shall ensure that She shall ascertain as to whether any part of the land claimed by the petitioners therein form a part of the railway land. The authorities conducting the land demarcation shall give a specific finding with regard to the land claimed by the petitioners in WPC 1907 of 2022, and then whether there has been any shifting of the position of the land covered by the Act number 338 of the 552 of the 317 from its original position as it existed when notification dated 28/8/1963 was published. So as to bring about clarity of the land claimed by the petitioners in WPC 1907 of the 2022 vis-a-vis respondent of 5 therein, namely Sri Jagannath Kumar. Seven accept to clarify the supposition, nothing more is required to be done by the land acquisition authorities, because the dispute, if any, between the interstate dispute, if any, between the petitioners and the respondent of 5, namely Jagannath Kumar, will have to be left to be decided by a court, by a competent court having jurisdiction, and which is not the subject matter of land revenue staff. Next panel. In connection with WBC 1838 of 2020 is concerned. However, it's also verified that the land revenue staff attached to the office of the Deputy Commissioner, Counter Metro Guwahati, is only required to demarcate the boundaries of the railway land in terms of gazette notification dated 28/8/1963. And they are not required to take any other steps, which will be left open to the to be decided. And for the next course of action, it is left to be decided by the railway authorities how they decide to proceed. Next paragraph. Insofar as just say the learned counsel for the NF Railways has referred to the proceedings of IA Civil 3645 of 2022 in WBC 1907 of 2022, and it is submitted that against the interim order passed, against the 21/12/2022. No, I was saying that Where is that order? Where is that order that any construction would be subject to outcome?
My lord, that was passed on 22/7/2022 in an IA 3645.
22/7.
22/7, my lord, in IA Civil 1789/2022 in WPC 1907 of 22.
1789.
My lord, 1789. In 1907. That order was passed on 22/7/22.
No, it has referred to the order dated 22/7/2022. Passed in IS Civil 1789 of 2022
Last paragraph.
in WPC 1907 of 2022. Where this court had made the following observations. Order sheet, huh? Starting from inverted comma, in view of the aforesaid facts. And last is read petition. Entire 2 paragraphs. First one. Next paragraph, accordingly, comma, the learned standing on the learned counsel for the NF papers is submitted that the said order was passed in an application filed by the respondent number 5 in WPC 1907 of 2022, comma, namely, comma, Jagannath Kumar. First of, accordingly, it's provided that the construction activity or development made on the
Old Doug number 549, new Doug number 317. Page 27 of the additional affidavit.
no. In this petition, what they have said. That number 552.
My lord will see that in the earlier affidavit by the circle officer, they are saying that.
No,
present-
I'm not on that. You see, this court passed an order based on whatever is stated in IS Civil 1789. Correct.
Yes,
In 1789, paragraph 5, it is claimed that the respondent of 5 is the owner, possessor of plot of land measuring 3 biga, 3 kata, 7 lecha, covered by Doc number 552.
and
3
new
and
Doug
7.
number 317.
Yes.
And if your lordship comes to the last affidavit of the circle officer, it says that the present 317 Doug number corresponds to old Doug number 549.
Maybe.
Lordship will appreciate that in as per the earlier affidavit, the present Doug number 317 had.
No, I'm not entering it at that.
No, my lord, I'm not.
I'll go by
asking-
only what
I'm
is.
not praying for a lordship to give a finding. We are not, because the lordship cannot examine this aspect. But the fact remains that 317 present Doug number was earlier 549. But in the earlier affidavit, they are saying that 317 had an earlier DUG number of 552. That there is the problem. So they'll have to clarify whether the present 317 was earlier 549 or 552. If that clarification is done, made out during the demarcation process, everything will be sorted out.
Oh, okay.
If 313, present 313 was 542, then it will be different. But if present 317 is 549, then 549 is a railway acquired land.
Oh, okay. So therefore, in IS, in IS civil 1789 of 2022, the respondent number 5, namely Jagannath Kumar, has projected that he is the owner and possessor of land measuring 3 bighas, 3 kathas, 7 acres, covered by DAG number 552 old, oblique 317 new of KP pattern number 60 within bracket old, oblique 419 within bracket new of revenue village Gotanagar, Moza Jalukbari in the district of Kamrup Metro. And based on the said projection, this court had provided that construction, if any, would be the construction of the development made on the aforesaid plot of land would be subject to outcome of the petition. It said observation shall the said observation is made absolute. Next part. At this stage, the Ghana Council for the NF Railways has referred to this statement made in paragraph
Roman 7, page 27.
additional affidavit is in
1838.
1838.
Running page 27, my lord. Roman 7, last paragraph.
Statement made by the circle officer, Guwahati Revenue Circle, within bracket respondent number 3, in subparagraph within bracket Roman 7, of paragraph 5. Which is already quoted above. We project that DAG number
300 and present DUG number 317 corresponds to old 549.
317.
Present 317. New present.
Where is that?
My lord.
Where is that?
Last page 28, again as per award list regarding acquisition of land
Okay,
measuring
okay.
covered by DUG number 549 old, 317 new is acquired railway land. Page number 28, the first paragraph, last 3 lines. So it appears that new.
No, just I'm not being able to follow you.
Roman 7 says
549 is old, 317 is 549 old.
yes, 317 is 549 old.
Okay.
But earlier they were showing
okay,
that
just
300.
that's right. It is projected that in subparagraph 7 of paragraph 5, we said additional affidavit filed by respondent number 3, namely so it has been projected that new DAG number 317 is corresponding to old DAG number 549. Full stop. However,
And the land measuring 449.22 R in 549 is a railway acquired land. That comes in the next page. Again, as per the award list regarding acquisition of railway, next page 28. Of that affidavit, my lord. Again, as per award list regarding acquisition of railway land, land measuring
and
49.22 R
and that
covered by.
as per the award list regarding acquisition of railway land, land measuring 49.22 R, covered by Dag number 549 old public 317 new, is acquired railway land. Full stop. On the contrary,
The earlier, the circle officer said that. Dag
where,
number-
Go there.
In the affidavit filed in 1907. One affidavit, that affidavit, my lord, I did not have.
Whereas in the affidavit filed by the same respondent number 3 on 1/8/2022 in the proceedings of WBC 1907 of 2022. It has been mentioned in paragraph 4 that
My lord, in that affidavit, perhaps
three one-
in paragraph 9. my
paragraph
lord,
9, no.
Paragraph
that
9. Dag number
that new Dag number 317
correspondence to old Dag number 552.
of KP Pata number 419 of
1907.
village Gotanagar is corresponding to old Dag number 552 . And that the records were corrected by restoring the name of previous Patadar by striking out the name of railway land. Full stop. In view of this discrepancy observed in the statement made in paragraph 9 of the affidavit in opposition of the circle officer within bracket respondent number 3 in WBC 1907 of 2022 and paragraph 5 within bracket 17 of a additional affidavit filed by the same authority in WBC 1838 of 2022, the concerned authorities under the establishment of the Deputy Commissioner, Kamra Metro Guwahati, shall also ascertain the correct state of affairs and shall record it in the order of in the order that will be passed in the demarcation case. Next paragraph. Before parting with the records, the court is inclined to clarify that this court has not entered into the question of right, title, or interest of any of the parties to this writ petition, and that if there is any inter-civic dispute between the parties with regard to the title or ownership of the said land or right of the railway authorities to evict the encroachers, the same would be dependent on the respective parties would be free to approach the competent court of law or authorities in accordance with law which by which they are governed.
And May I say one thing, my lord, the demarcation should be carried out as per the map,
That I've
pedestrian map
already
of
mentioned,
nineteen
that I've
sixty.
already mentioned, next paragraph. The,
Question, no? I'm sorry. my lord.
the
I
demarcation
missed it.
shall be brought to its logical conclusion within a period of 2 months,
Yes, from today. Reasonable.
to 2 months from today. The pillars will be providing pillars.
Railway, railway will provide the pillars. no?
Huh?
Once
And if-
at the time
And
of.
if required, the and if railway shall be ready and willing to provide the boundary pillars for demarcate to, for official demarcation of the land. Correct? Yes, for the petition, the in order to protect the interest of the private respondents, the private parties to this petition, it would be open to the deputy commissioner to give them an opportunity of hearing, if so required.
So in fact, entire exercise may take some extra time, so I
It is
think now
almost done, my
3
lord.
months may be more reasonable. 3 months. It's a huge area, it's a huge area.
45 villages is not a huge area.
But
45 bigger one is not a-
45 villages is not a huge area.
45.
The time I'm giving only for the purpose of hearing. Uh, You just said that preferably within a period of 2 months, preferably.
My lord, my presence may be required. I am assisting Mr. K. Dasgupta.
I have recorded his presence, in fact.
Assisted by me, my. In
Yes,
1838, I am appearing.
I have recorded that.
Good now.
He has ensured your presence. So you were there, you have heard, you protected your interest. Not only once, twice, we are also giving an opportunity of hearing to the deputy commissioner.
I'm like,
Should I say one more thing? Can you give a date of appearance of the parties before the deputy commissioner? No.
For the hearing,
Huh?
that would be moved here.
Hmm?
That would be moved here after the demolition.
Just add there. Huh? It is the opportunity of hearing, and according to all the parties, we produce a certified copy of this order before the circle officer, Guwahati Revenue Circle, within bracket respond to 3. And a payable for the said authority on the date after 10 days. Page 7. On 25/6/2023. So as to enable the said authority to fix a date for hearing of objections of all the parties. Connected interrogatory applications, if this on this point of the first one. They can come back.
That's all right.
You'll have to take time only. You can't do anything more.
Yes, my lord. From the very short better is unable to, my lord, from this communication, it is not clear whether it is.
No, it is very clear. That is why I'm taking time to
Yes,
uh, to think what I am to do. Because this communication is very clear. It was never placed before the governor. So Chaudhary has a strong point. Let us see what comes. Sorry, Chaudhary, don't say. We are giving them some time. They want opinion from the legislative department.
What happened in the meantime, the program is that proceeding with that. Election, brutal days, etc. This is the, that's why we had a miscase also in item number 8 now, 8 and 9.
Lord, can I take your lordships to article 154?
154, yes. Just a moment. Just give me 1 minute.
That is good.
Yes, 154.
Executive power of state. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with the constitution. So therefore, my lord, I am directly involved here because I am a formal party. I am executive officer, Silchar Municipal Board. But then just I thought that to take a lordship to this provision, saying that the governor may do it directly or through officer subordinate to him.
No, you see, then the order would have been that the competent, that the governor accepts the executive, what you call decision of the authorities in rejecting the claim, but that is not done. Here it says that the governor has recorded his assertion. The governor has rejected it. So rejection is not by executive. Look
by
at the
by the
Yes,
governor.
language is.
look at the language. Read that that language.
Page 131. No?
The governor was pleased to reject it.
Yes. Page 131 of item number 8. Page 132. madam. This is-
Whereas after detailed deliberation and examination of the claims and objection, the governor of Assam is pleased to dispose of the petitions.
Last paragraph.
Not last, second last paragraph.
Yes.
Whereas after detailed deliberation and examination of the claims and objections, the governor of Assam is pleased to dispose of the petitions. So this is a personal satisfaction recorded.
Your lordship is reading notification dated 28th November.
20 November 22.
20 November 22. This
So
is a draft for item.
satisfaction of
Yes.
the governor has been recorded.
Yes.
That means he did it directly.
Otherwise, it would have been in the name of the governor, the petitions are rejected. Then I can accept your argument under 154.
By the governor himself.
This is supposed to be in the name of the
Very
governor.
clear now. One judgment I got from Madhya Pradesh High Court. May help. It's by governor, since it's not done by governor, it is disputed.
This is a Supreme Court judgment.
No, it is one of the.
I have a Supreme Court judgment also.
That of course, yesterday I could not find. So it was in the draft page, my lord.
It's okay, I myself use rock papers. Mr. Chidha, how much time you require? Because I have to, what you call, give an interim order. Not to proceed with this, not to act in accordance with the notification.
Miss this, could you? Miss this, could you?
No, because I'll be staying it. That's why I'm asking you. You take your call because 3 weeks would be, it would go after vacation then. The effect of the order would be. Because there will be vacation. So in fact, 3 weeks will become 6 weeks.
Before vacation, my lord, any day.
Huh?
Before vacation.
Choose a date because you will have to get it, the opinion.
26.
Make it 23rd because 26th I want to be free this week. Just before vacation, there will be a lot of pressure.
27.
23rd. Uh, Last week would be too burdensome. How do you say, Acharya Chaudhary and Senior Counsel, assisted by Mr. F.U. Barwaniar and Counsel for the petitioner. The petitioners. And Mr. S. Dattal and Senior Counsel, assisted by Mr. A. Upamanyam, Counsel for the.
No, 5. Dr. Mr. Dr. 5, executive
sorry.
officer.
For the executive officer, Silchar Municipal Corporation. With bracket respond number 5. Next paragraph. Mr. M. Sethial, government advocate. Has produced an interdepartmental communication dated 3/6/2023, which is also marked to the learned additional senior government advocate. And it is submitted that the matter has been sent to the legislative department of the state to obtain their opinion, or obtain their view. So accordingly, the learned government advocate, has paid for and is granted time till 23/6/2023 to address the court on the query made by order dated 29/5/2023. Next, by the copy of instructions produced are returned. Next, the learned senior counsel for the petitioners has submitted, has made a prayer for, has pressed the prayer for interim relief on the ground that if there is any delay in adjudication, the inclusion of two
In the three case different villages, different
Hmm.
panchayat. Three cases different panchayats.
no, this 605 is of which now panchayat. I am passing one by one,
Mr. One,
by which Kanakpur,
yes,
part 1 and
Yes.
part 2
yes.
under Kanakpur Gaon Panchayat would be merged with the Silchar Municipal Corporation, which would affect the rights of the citizens. Full stop. The learned senior counsel for the respondent of 5 has opposed the prayer. 5 as well as the government advocates oppose the prayer. Full stop. Considering the fact that there is no clarity as to whether the file relating to issuance of notification dated 28/11/2022 was actually put up before the Honorable Governor of Assam, till the next returnable date, i.e. till the next returnable date is provided that the notification dated, the notification dated 28/11/2022 shall not be acted upon. Next, this one, so. The petitioner shall produce a certified copy of this order before.
Sorry?
You will produce a certified copy of this order before,
Before executive officer, it will be 5 minutes.
before respondent 5 to bring the order to the notice of the said authority.
5 minutes. 5 or deputy commissioner, my lord, that will be 3 and 5. This is the main matter, district collector. 3 and 5.
No, I think deputy commissioner has got nothing to do with it.
Yes, but he is looking it. The deputy commissioner is looking for it.
No, he can't. It's a Silchar municipal board.
No, municipal corporation has not yet been constituted.
Well, it's a board only.
It's a board. Whoever does it,
Yes,
whoever does it is the board.
that way respondent 5.
It's respondent 5. I'm returning you back this one. Next day you place it. And in the other repetitions,
Yeah.
Mr. Babu, you just write the village number and give it to the court master.
Yeah.
The other 3 repetitions.
Village.
Village, huh? Just give that. Then I would not be required to open the file.
The number 10. This is also my lord. But of course, madam, Mr. Doctor is not here. Cooperative man. So,
You pull him back, retain him.
no, I am not. Let him enjoy, man. Let him go there, man. Enjoy, man. I am not troubling him, man.
Well, I could not get what Mr. Chaudhary is saying.
No, and The long and short of it is that he's trying to pull your leg, but you did not hear it.
Fortunately, I could not hear
Fortunately.
About next item I'm saying. Yeah, one copy will be given to him, madam. in most cases.
Huh?
We'll submit a copy, supply a copy to him, madam. About so far earlier item number 7 to 9.
No, you have to give it to the board. You can give a copy to him.
Yes, that's what I'm saying.
I
And
think,
him also inform my lord.
I think it is gentle like pulling me.
Yes. Because in the next matter, you are not there. So he's saying that he would want you to be free and enjoy there.
I'm obliged to him.
I will share my lord, whatever he will take there, my lord, we'll also share.
Now is the real point.
My lord, this is a case.
Just a moment. Until I read it, I won't remember. Yes, you're there for the Corporation Department.
I'm item number 10, I am the respondent number 6, Lordship. We need time to file a affidavit in opposition, Lordship.
Remember?
In item?
Item 10,
Item
Lordship.
Yeah.
Yes.
One private party is there, my lord.
My lord, in this case, my lord, I am appearing for sin number 5, my lord.
No, I would regard this. This is what you call this. The society.
My lord, yeah.
I will wait for Mr.
Yeah, Talukdar.
Talukdar. Yes.
Last time matter was there, my lord, he took time to do the.
SK Talukdar, SC Corporation. Just wait for some time.
Fine.
Let Mr. Talukdar come.
That was both.
After some time. Yes, 11. Number 11. You are referring the matter? Yes, what is your stand?
Actually, we have to receive an instruction now.
What instruction? Okay. None of present call for the petitioner. So say and go submit and counsel for the government appealing for the respondents. Praise for is granted. Who will stand to file affidavit in opposition to the matter? First off, interim order passed today stands extended to the benefit of the state. Petition is not there. I think he has got the relief, I think.
Right.
I'm trying to find out. Yes.
Here we are not. We had come to this honorable court, sealing the impugned act of putting a lock in the refreshment room of the petitioner. That photograph we had annexed at page 19, Lordship. And on 14/2/2023, this honorable court had passed an interim order pursuant to which the lock was open on 9.
So, Mr. Gogoi, you are referring the matter?
20. Oscar Gogoi.
Is that review matter?
In this case, lordship, we did, my sister has given one copy of the affidavit, probably whether it is in the record or not, I have. Today morning, I have received the same. letter.
The affidavit of?
An additional affidavit. was
Additional
filed,
affidavit.
Lordship, today morning.
Oh, it's not here.
May not be.
It's not here.
Then I have also gone through this.
Okay, what are your instructions about the, about this
Regarding this,
blocking?
already they have running losses.
She's running it.
He running losses.
Since the lock was open, after that I have been.
Lordship, as per my lordship, lordship, they are now operating lordship.
Acha,
Yeah.
because of the interim order.
Lordship.
Acha, acha, okay. But this,
Is the matter
the-
after 10 days lordship.
Mr. D. Chaudhary, Leonard, the counsel for the petitioner. Mr. K. Govil, Leonard, CEC, appearing for the respondents has submitted that he has just now received a copy of an additional affidavit filed by the petitioner and seeks some time to obtain instructions. So it is submitted that pursuant to the interim order passed on
14 to 20.
14/2/2023, now the petitioner has been allowed to operate the stall. This one. Next one, the registration track and tag this at affidavit, additional affidavit by the petitioner on the record. We'll fix it after vacation. Before vacation,
On 23rd or 22.
21st,
Lordship.
21/6/2023. Okay.
Obliged, but interim to continue.
We get it to- if not afterwards, and extend it to the next day. Thursday. Oh, affidavit has come. Affidavit has come. Affidavit has come. It's not the problem. This is- I don't know what then.
I'm sorry.
Just, there's a bail matter pending. Mr. Mr. Kaluga, in this case, you have instructions?
In fact, I have the instruction, madam, but a very one page instruction.
Cryptic.
Yes, madam. It says, my lord, that some anomalies were found. So therefore, the, my lord, register under exercise of power under rule 27. My lord, he has interfered with the, my lord, in fact, the election process.
But
So there is one, if I'm not wrong, there is one application. My lord, so affidavit. Filed by respondent. But in this case, my lord, I am appearing for a 5, my lord. I have filed affidavit.
yes,
The complaint of.
because Mr. Chaudhary,
My lord,
I think this matter has to be adjudicated by the registrar himself. What I found from here is that they are the respondent of 5 has admitted that the notices were not correctly served. Then there is also a statement made by this respondent of 5 that the voter list was not correct and the names of dead people were also included. So if that is the case, then I think we'll have to.
that order was passed by the register itself, my lord. One shareholder filed an application before the minister, my lord. And this minister according to the director, my lord. Director passed the order without hearing me. And
No,
that is
but-
after election, my lord. After election was held. They have not challenged, they should have challenged the voter list, my lord. They could have filed the objection about the voter list. Nothing was done. Simply kind of politically filed a petition with the minister prior to the election. In the election also held. The result declared, my lord. What the certificate also the election. You know, kindly see my respondent number, let's say, my page 79. That it is given to minister, my page 79. Everything started from that, my lord. Page 79. 9/3/23, locally note the date, my lord.
Yes, 9/3/23.
Yes, your lordship will find that the ex-chairman, your lordship kindly note by the first. The ex-chairman of the society,
Okay, just a moment, Mr. Chaudhary, because I think this will take some time. I'll make free Mr. Sharma, his APP sitting for a matter. Where is the petitioner in that case? 16, who is there?
my name is there, but I do not know why, because some. Because of it.
16 is, yes, your matter,
My name is there, but I do not know why. I have not been.
briefed. Huh?
That too much, that will be better. I will inform them.
Yes,
Madam, this year lost time, page 79.
yes, 79, you have shown me the date,
Yes,
9/3.
90.
What is the significance?
It was submitted to minister, my lord.
Yes,
My first year kindly say date, my lord, that will be better, my lord. Earlier board expired on, that will be better. 6/5/2022. Because of the failure of the automatic to hold it.
board, what you call,
Earlier board, my lord,
that's
expired 6/5/2022.
6/5/22.
2022, my lord.
Yes,
Then one man committee formed on 17/12/22.
I will not pay one. I am appearing for one number. My lord, I am appearing for respondent number 6, my lord. He is the main complainant, my lord. He is, my lord, willing to, my lord, file one affidavit in opposition in this matter.
what you call, can I have an idea of what is the stand she is requiring to take?
My lord, she is the, my lord, main complainant, my lord. I the complaint, my lord, against the, my lord, this election, my lord. And considering her complaint, my lord, this election was cancelled, my lord, under rule 27, my lord, by the register, my lord.
Correct. Now,
Para, my lord, 11, my lord. Page 14. my lord.
no, you see, notice was served to you on which date?
Hello, which?
Notice was served to you when, Mr. Bhavia?
The file follow from a when that will be. The file follow from a while.
Sometime in April, May.
The last occasion their name appeared, my lord. Last on 1/6, no?
Your complaint is at page this
79.
79.
Yes.
Do you dispute the correctness of this statement?
My lord, I am just, my lord, received the, my lord, brief, my lord. So,
No, because you see, the elected committee has been the elected committee has been interfered with.
yes, my lord.
Correct. Now, Mr. Chaudhary is made out a point. He's showing us that the board had expired on 6/5/2022.
And everything was done by the one man committee.
Correct.
And she has written everything done by me. This is the whole problem, my lord, your lord. How it can be done. She is saying ex-chairman society has been running the society.
That is something not possible.
Ex-chairman circulate notice. This is the thing.
That is something not possible.
It's actually not correct also.
So we give you 7 days time to file a affidavit, otherwise you will hear the matter. Because this matter has to go back to the what you call the register of cooperative societies, and there be a direction to hold a inquiry, and and if it is, and if there is no basis inquiry, then the board will be restored, and if there is some basis, then he'll hold a fresh election. Their adjudication, you can just postpone by 10 days or 7 days, but that is what the order will be passed. You see, your complaint has come after the board was dissolved. And you did not make any complaint when the voters list, according to the voters list, the election took place. After that, how far it is possible to you to challenge it?
No, but one thing I clarify, man, on something maybe on clarify. That board dissolved, it has gone. Subsequently, for the new one-man committee has issued notice for the first new committee. New committee also got elected, madam, where we have been elected. That dissolved, my lord, the new committee also, we got the certificate also within 7. Then this order came, man. 18-3 is the order, madam.
So give you 7 days time. You file it within that time, otherwise you lose an opportunity of contesting. Today, we'll take it up on 14th. The 14th you file a affidavit. Mr. HRD Chaudhary, the Senior Counsel, assisted by Mr. F.U. Babner and Counsel for the Petitioner, expresses urgency in the hearing of the matter as his elected body, as the elected body where the petitioner was the
All the petitioners are elected chairman, board of directors,
the petitioner were elected members of board of directors
18-3,
have been
18-3-23.
have been prevented from
Because there is no contest at all, my lord. Total seat 15, total 14 in the frame.
have been prevented from acting as a board of directors. Mr. S.K. Talukdar, Standing Counsel for the Corporation Department, is present. And he submits that he would be making his submissions on the legal issues involved in the matter. Mr. J. Islam, the Counsel for Respondent number 5 is present and submits that he has filed his affidavit in opposition. Next, Mr. A.M. Barbuya, Counsel appearing for Respondent number 6. Place for some time to file affidavit in opposition in the matter. Next, having noted that the validity of the previous board of directors had lapsed on 6/5/2022, and elections were held by a one-man committee appointed by the Corporation Department, and court is inclined to grant time to the respondent number 6 till 6/6/2023 to file affidavit in opposition based on 7/6/2023.
Today, my lord, 8.
Oh, I'm sorry, today is 8, sorry, I'm mistaken. 14/5 and 15, sorry, 13/5 and 14/6 is the later listing. 13/6 and 14/6 is the listing. My calendar is stopped. My calendar is stopped. Right. This is at 2 o'clock. So I'll rise early, then at 2 o'clock we'll take up the bell matter.
Time is also there.
1
o'clock, 5 minutes.
5 minutes.
Compliant.
In fact, Mr. Chaudhary, now after we are getting 15 minutes more, it is so relaxing to me, for example, that you can't even imagine.
That's what we are thinking, madam, what
Out
actually.
of earlier we had 45 minutes, out of which 30 minutes used to go in administrative works and the other works, which are incidental.
So now this 15 minutes of what? Given my that is.
I think we are deserving it. But we have some time for ourselves. Otherwise, even we don't have time to eat food in an appropriate manner.
There is some movies there after vacation, maybe again the earlier time they will explore.
I don't know, but this is something very,
Yeah, but it
it
is.
gives some amount of relaxation.
Someone will convert some others, madam. This is how it happens.
Some amount of relaxation you get.
Whole point
Others-
10-15 miles, this is the problem. 10-15 is the problem. For some people, who are having children, they have to go to the school, the traffic is there, that is all. 1 hour, that's no problem, madam. But
No, you see here the what you call the natural clock. I think by the time at 10:30 we are sitting, it would be 12 o'clock.
no. That is,
So effective time you're not getting. In fact, we should make it advance. And this 15 minutes of advancement, I find even the traffic is not there.
no, traffic model is start, the schools are there nowadays, schools start at 7:30, 8:30, this. The schools are advanced nowadays because of this.
No, at 10, for 10:15 to come to court, I don't find traffic. But at 10:30 when we used to come, there was a
face
traffic.
trouble matter, your lordship naturally, even at 11 also your lordship may not face trouble matter. But traffic, we face it matter, your
No, no.
lordship come through matter.
Traffic is for all, everyone. Traffic problem is for everyone.
Or sometime I come from Guwahati club, sometime it take 15 minutes time. Hardly 5 minutes time only, it take 15 minutes.
No, but when this 10:15 now, do you have that problem again? No.
No, problem is there, matter, because my mind was set at 10:30. All along, matter, all along the years. People
No,
are
no.
adjusted to that life, matter.
If I have observed you correctly, I think you wake up for the morning namaz also.
So that is there, but then I go to bed again. Well, the problem will remain whatever we are. Somebody, some inconvenience to someone, some convenience to someone, it will remain like. So nobody will be satisfied, man. Whatever time you adjusted, it maybe even 11 also, some problem will be there, man. So with all we have to adjust ourselves, man. That way.
But in fact, it is giving me some relaxation.
Yeah. पेपर आते हैं
Cover this and inclusion of technology are not expensive or fees, but we. Then a pattern activation of the people back in the but again to Baba to other inclusion of ethnic and then to say a strongly getting ready to be so we can talk about some by the time this some of us some using Allah Allah and then we team strongly than the country example like see that that subside on the stream and remember you have falling off of the bar expansion after them then the sleep the more personal and it is and the second that's a small bit of peanut. Over the hand without enough grab them in his hand and he gave the skins and they kaka eat them. That into the house and making kaka chicken then a son of the Baba himself ate some of them. When the big was spirit Baba asked him to catch someone that like he was hoping that kaka so the water then Baba drank some water and live that out with himself. Baba then said now you that it was cold and he met that in the water for me. Then he had the beauty had run and starting the and kaka motion has stopped. Also joined them are events for them according to line with the opinion. Finance might activate that also the ability that are the discipline of our goals. Activities and another of gentlemen partner named the people. Some of those of and see and cover with that and face them and places man on the 2 pounds and when he received the covers and good classes from and one thing of the 3 cases are second one but what is found and it's some suffered from time cover every function of tsunami and seminar bonds and distributing. Then after 3 years, the subsequent because and after the same foundation, some function with the consulting cover that resembles the also once upon and you are benefit then he until the which actually the kind of that is making comfortable on the so that Side, the life of life exchange, that's why it's and after things are back side as a news for them we get them the estimate of the next and it is worldwide, which is key, where the inclusion of the party is that, so we should never release the vaccine on anything about that, in our in and in life.
Last. The early rejection order, where is that?
The rejection order is pays, my lord. Last rejection order to complete. 19/1/2023.
Where is that? Which page?
Page 2021. Oh, additional affidavit is there. My lord, in the additional affidavit, my lord, it's on that page number, my lord, 39 to 42, my lord. Annexure 6. Page 31, my lord, annexure 6. Order dated 21/9/2022. MS Ajay Borua, Running Counsel for the petitioners and also administrator. Bhaskar Sharma, Learned AP, appearing for the state. The petitioner number 1, who was arrested on 14/5/2022, and the petitioner number 2, who was arrested on 17/5/2022, are seeking regular bail under section 439 CRPC in connection with the Zagreb PS case numbers 210/2022 under section 7 corresponding to case number 7. In connection with the said case, charge sheet has been submitted. Charge sheet number 7 dated 7 was submitted before the court of Planet Chief Judicial Magistrate Morgan, and according to the case is being tried as session case number 7 under section 7. Ordinarily, when the petitioners have suffered custody for 126 days and 129 days, respectively, the case should ordinarily be called for. However, in the present case in hand, as per the affair dated 13/5/2022, the informant to leave from Khanapara, Guwahati to Nagaon. However, the
driver and one person got down from the car before reaching Ganesh Mandir to have a cup of tea. After crossing the Nazire Ghat toll gate, the informant became senseless, and after he had regained his sense, he found himself near Nagaon, a paper mill beside the road, and thereafter he had realized that his mobile number, charger, rupees 20,000, laptop was a key of a car, important file, clothes, etc. were all stolen. He was admitted in Guwahati Medical College and Hospital, Guwahati, for 3 days, and then he was released. Therefore, he apprehends that he was administered with some intoxicated things with the intention to kill him. Subsequently, in course of investigation, the two petitioners were arrested. My lord, the in may I read 161 statement of the victim, my lord?
161.
My
Yes, where is that? Which page?
My lord, it is collected from charge sheet, no? It is collected from charge sheet, my lord. It is written here.
You give it to the learned APP. I'll be hearing you. Give a copy to sir. Sharma.
My lord,
On page
my
number
lord,
53,
the copy of the additional affidavit, my lord, that is not.
page number 53 in the last form.
I have gone to the scan copy, my lord.
Huh.
And my lord, kindly, my lord, go to the charges, my lord, charge sheet, page 30, my lord. It was the both the petitioners are, my lord, identified by the complainant, my lord, in TIP, my lord. And my lord, that stolen articles
Were recovered.
all are recovered. from
Mobile
them.
and the smartwatch were recovered.
Yes, my lord, from them, my lord. And only 2 witnesses are examined, my lord, out of total, my lord, 11. Now, my lord, only 2 witnesses have been examined. by the honorable court.
But if there is a delay, we'll have to enlarge him on bail.
That is, my lord.
Because if he's in custody for 383 days,
Yes.
more than a year, he's
Yes.
inside.
With strict condition, my lord.
Hmm?
With strict condition.
And what has happened in that another case where he was accused case of murder? A dead body was found in another case.
Yes,
In
my lord,
another case.
that record is not them.
No, the stage of trial of that case.
Yes.
Can you find
my
out?
lord, we have to call for my.
Can you find out?
Lord, we have to call, my lord, scan copy of the latest, my lord, status report of that case, my lord.
No, that case number is not available.
Yes, ma'am.
It is not there. This
In the
here it only says, it only says that he is an accused in so and so case number so and so. The trial number is not there.
in session case number 194, my lord, there is another bail petition was filed, my lord, today.
Hmm?
In case of this murder, my lord,
Huh.
suspected case, my lord, another bail application has been filed today. Session case number 194.
Sessions case 192. That is listed when?
222.
That is listed when?
94, 194, 2022.
It is listed when?
No, today, it's today on the file, man.
Also, today you have filed.
And the deposition has been taken of the informant. Even on my lot 19/1/2023. After then, my lord, there is no any further witness has been examined. My lord.
Okay, so we'll take it up next Monday. In the meantime, you see what happens to that bail application. Because we want to know the status of that case also. Alright. It appears that Mr. B. Islam, counsel for the petitioner, and Mr. Bankim Sharma, the APP appearing for the state. Next, the learned APP has submitted that the petitioner is also an accused in, yes, which case?
The session case number 194
Sessions case number 194
of 2022.
22. Where under similar circumstances, the victim was murdered by administering poison. So he submits that. He submits that bail application has been filed in the said matter. And would like to go through the said record before addressing this court. First of all, accordingly, matter since adjourned to the district again on 19/6/2023. The APP is permitted to send a download copy of this order to the concerned police station.
My lord, maybe through the registry, my lord, because it is, if it is in trial stage, my lord. It is difficult for me to.
Actually, it's okay. Just say that till the end there, take it on Monday. Monday we'll see.
My lord.
If the bail application is there, we can call for the record and examine it. But the only point is that he's more than a year inside.
Yes, madam.
Whether not
That,
can be
that
still
aspect may be considered. But with some strict condition. my lord.
Monday. 12/6. 12/6, not 12/6.
12.
12/6.
Deep level.
Mr. Islam, you on that day, you carry your this. Well, next Monday, you carry that bail application also. We may like to see it.
There is another mail.
Be ready with that also. That record, your bail petition, please carry it on that day.
I will try.
Part 2 hearing list, item number 4.
Yes. Yes.
May I please, my lord, in this petition, the notification whereby, my lord, some of the villages are included while constituting the demo town committee, my lord. So that notification is challenged, my lord, and my lord, it is challenged mainly on the ground, my lord, that section 344 of the Assam Municipal Act provides that while constituting any town committee, a notice is to be issued by saying that all these area to be included in the town committee. And that notice to be widely circulated, then objection is to be called. And thereafter, the authority will decide. In this case, my lord, this notification was not circulated widely, my lord. If lordship may kindly come to page 27, my lord.
A notification published in the official gazette is a good circulation.
Yes. My
You
lord,
can't, nobody can say that it's not widely circulated.
my lord, my submission in this regard is, my lord, that although the act doesn't say that how is to be published, my lord, but these all peoples are from a village, my lord. And my lord, village people, it is very difficult to say that they have access to the gazette notifications, my lord.
No, you see, somebody may come up and say that I don't read newspaper. Somebody will come and say that I don't see TV.
My lord, that,
Somebody will come say that no radio, I've never heard of a radio and I've never used a radio.
my lord, lordship may be right.
Because
but
also
my lord,
press
that-
release also real, lordship. Press release is also real, as you have mentioned your affidavit, lordship.
my lord, lordship is right, but my submission is that, my lord, at least they ought to have published in a newspaper, my lord. Then the authority can say that this is a widely circulated news. Because it is only says, my lord, if lordship may come to page 27, my lord, the director government press Bamuni Maidan for publication of the notification in the next issue of Assam Gazette and sending 25 SPL copies of the notification to this department after such publication. Page 27, my lord.
No, was it published, Mr. Goswami? Was it ultimately published in the newspaper, in the gazette?
That is there, lordship.
Huh?
You know, affidavit,
Two affidavits are filed, my lord. One is filed by the respondent number 3 and 4, my lord. And they have also stated about publication in the official gazette, my lord.
But have they produced the official gazette?
My lord, the gazette is not annexed.
No, gazette is there.
Yes, gazette is there.
Yes,
Page,
yes.
affidavit in opposition filed by respondent number 3 and 4. Page
Is there.
20, my lord.
Hmm. Do you have any authority on the point which says that publication is the gazette is not equivalent to wide publicity?
That I do not have a specific judgment, my lord, but lordship, my lord, the 334 to section 334 to of Assam Municipal, it says, my lord, a copy of the notification under subsection 1 shall be published in such places as the state government may by general or a special order direct. Section 334, subsection 2, my lord. Assam Municipal Act.
Municipal approach. Section?
Section 334. Subsection 2, my lord. But even this notification is not published in the DC office or the Gaon Panchayat office also, my lord. Had it been there, my lord, they ought to have come to know, my lord. My lord, these all are village people's, my lord, and their main grievance is that, my lord, if this will be included in the town committee, then the Manrega and all these schemes which are there for the village people, my lord, they will be deprived of that and they will be burdened with the taxes and all this. All these are agriculture, they are basically dependent on the agriculture, and my lord, they are agriculture laborers, my lord.
Director of Information and Public Relations had newly issued a press release, Lordship, in this regard. Lordship, Director of Information and Public Relations, Lordship.
Where is the press release?
That is a affidavit filed by the Russell Respondent one, Lordship.
No, but where is that press release? Where it has been published? Which newspaper?
That is not there, but in Assamese and English language, Lordship.
No, if they don't produce any newspaper, it can't be said.
Lordship.
People may not want to publish things sent by the director.
And Lordship, setting up of a official debate town committee on a temporary basis has already been done. Lordship. It is also there. Temporary town committee office is also set up, Lordship.
These BPL cards are not valid in urban areas.
No. This Manrega scheme and all other some schemes are there, my lord. BPL card is valid, my lord, but the other Manrega and all their some schemes are there which is only applicable in the village areas, my lord.
Demo town committee has filed an affidavit? No. Alright. Demo town committee has filed an affidavit? No.
No, madam. Only two affidavits are filed, one by the respondent number 3 and 4 and one by the respondent number 1.
Demo town committee has not even been made a party. Your reflection will go on non-joint or necessary parties.
But my lord, since no relief is claimed against the demo town committee, my lord.
No, they are the affected parties. If I take
Demo
away their
town demand committee is also real also. Demo town demand committee.
demand committee is.
Somebody has demand also not. For
That's
town
okay.
committee also.
You see, merely because I form a committee saying that this, when
Nagarik Bansal.
no, let us say this is Latasel area be included in the village demand committee. Merely because I open it, I will not be entitled to notice.
Lordship, besides the office bearer of Demo Regional Students Association, Demo Press Club, Employees Association, Marwari Yuva Mancha, Yuva Chhatra Parishad, Thai Ahom Students Association, Thai Yuva Parishad, Thai Yuva Chhatra Parishad, Demo Business Associations, Brihatar Asomia Yuva Mancha, and hundreds of senior citizens were also present in the meeting. There is some people also there who is claiming for it also town committee.
So these people are not, everybody will not be entitled to notice. But if the town committee would be a necessary party.
Kindly see the affidavit filed by Lordship, Deputy Commissioner Lordship.
Deputy Commissioner is respondent number
3.
madam. Yes.
Page 7, Lieutenant 1. Honorable Shasan Officer. We want to intimate you that 2nd July last a meeting was held under the Demo Nagarik Mancha under the presidency of Ajit Anil Kumar Day in Demo Public Health. Besides the office bearers of Demo Regional Students so are present. In the said meeting, a resolution was passed to form a Dabi Committee to declare Demo a town committee in the name of Demo Nagar Dabi Committee. We therefore request to take necessary steps to declare Demo as a town, keeping view of public demand of public having about 15,000 population. There is some organizations also demanding lawsuit.
These are all set up documents.
Lordship.
This document is a setup document.
Lordship.
This document is a setup document.
Original is there, Lordship.
I'll tell you why. You start reading from the first paragraph. You will understand. We want to intimate to use that so and so. This is just like a what you call departmental head writing to Deputy Commissioner for eviction. I am directed to inform you that this land has been encroached. We will make it encroachment free. You remember that this is how they write. You look at the entire letter. There is not a request.
The original vernacular is also there, page 9.
But the person who's authoring it, he must be a politician or a because therefore politeness is not there. An ordinary person who makes a demand committee, he will not write like this. And he's the chief secretary.
That's it.
And it is not even registered. So this is, you can't take cognizance of this status. Page 8 of your report doesn't even say how many people attended. There's a demand committee. Resolution taken. The government moved. Within how many days this notification came?
January 7.
20 July 2010. And when this town committee came out? Within 6 months. So now you understand what is the setup matter. You try to write the representation to the government without disclosing your identity. Say that your tap is not working. The municipal water supply is not functioning. Just you'll get the manner in which the town committees move.
Press release is also real lordship.
Where is it?
Page 22, Annex 8. The affidavit filed by the Deputy Commissioner lordship.
You see, this is something which you are doing politically, that's okay. But now you see, you come to page 12 of your affidavit.
But
Existing population of Demo town, last paragraph, is about 7,007.
not
Most people at Demo is migrated from, no, not that. Yes, the previous paragraph, last line.
lordship.
The airfield located at Jorat and Dibrugarh is at a distance of 17, 76 and 82 kilometers respectively. So just imagine from our Borjar airport, 76 kilometers or 82 kilometers. Every area, have you made it a urban area? Guwahati airport is a bigger airport than Jorat and
Lordship.
Dibrugarh. Do you think that 82 kilometers radius, every place is a urban area in Assam, in Guwahati? Do you think so? So when you politically want to move it, then anybody's representation you can move. This is something not. Where is your press release? Show me that.
Lordship. There is Annex 8. Page 22.
Page
22. Running page.
22. The who is a town committee or is a, what you call, a municipal board,
Town committee.
Hmm?
Town committee.
town committee?
Yes.
Which page is that notification?
Page 27. 27 of read petition.
Because, Mr. Whether we are not finding anything to say that, what would constitute a wide publicity. I have to dismiss your petition. Can't help it, there's a gazette notification. Yes. Where is the final gazette notification of declaring it?
That is 28 now.
28.
28.
Well, that's. We can't save it. We can't save your petition, it has to be dismissed. Can't be saved. It's 28. All in book is 334. Sorry, you issued a notification under 334(1). You read this 334(1).
The state government may by notification signify its intention to declare that with respect to some or all of the matters upon which a municipal fund may be expended under section 60, improved arrangements as required within a specified area. With nevertheless, it is not expedient to constitute as a municipality.
Is it empowered to include villages? Now, in this book, come to page, say, section 60 referred there.
Lots.
One is for a different purpose, 4 is for different purpose. It is for declaring a small town.
Gotcha.
The power to include area is where? Power to extend is not there. 334(1) relates to powers under section 60. 60 says all those things which you have read. It doesn't have power to include. I'm taking Gupta and counsel for the petitioner. As well as Mr. N. Goswami and government advocate appearing for the respondents. Next paragraph. It appears that by the notification dated 2/8/2012 was issued for inclusion of certain areas to be notified area of Demo Town Committee in the district of Sibsagar. Most of the said notification was issued under subsection 1 of section 334 of the Assam Municipal Act, 1956. No, 4, subsection 4 of section 334. Full stop. In this certain notification, it is mentioned there are objections. That notification under subsection 1 of section 334 dated 7/1/2012 had expired. First of on a perusal of subsection 1 of section 334, it appears that it is the said provision does not contain any clause for inclusion of any area in the municipality. But first of all, on a plain reading of subsection 1 as well as subsection 4 of section 334 of the Assam Municipal Act, it appears that two provisions are not in support of each other. So therefore, the learned government advocate shall address the court as to how subsection 4, subsection 1 of 1 is of section 334 is related to subsection 4 of section 330. 4 of the Assam Municipal Act of 1956. Matter would be taken up in the next one. Next Tuesday, we are taking it up. So that is the only issue now. 334.1. How is it correlated to 334.4?
Next is the.
In the meantime, we try to find out if there is any newspaper following it. Press release.
Always. Let.
In this case,
Hello,
also
sir.
standing
I
council
said
of health is
let us-
required. Also.
Hmm?
In this case, standing council of health is required.
Health,
Health is required. Also.
SC Health.
Oh, this is mainly the revenue department. For the health, it was taken, but notification is issued by the revenue. I said place the synopsis, my lord, past, my lord, because a long, my lord, matter is there. That will give the probably idea to you. Your lordship may just see the synopsis in the requisition, my lord. The land of prisoners was requisition measuring about 3 kata 13 inches and the dark numbers so and so in the year 1981. It was requisition, my lord, under section 3(1) of the Assam Land Acquisition Act 1964. And the same was delivered to Guwahati Medical College Authority, who obtained possession of the over the aforesaid possession land without any giving notice and also made a construction over the aforesaid plot of land. Master of the petition after 21 years, that's number 2, by notification number 41, under section 41, being RL number so and so published in Assam Gazette, but such notification was elapsed due to procedural delay. Left. The petitioner even prepared a petition being number so and so paying for de-requisition of the land, but since the respondent stand was that the land was urgently required in view of public purpose, directed the respondents to decide the matter within 1 year and also pay the entire rental dues at 15% per annum. However, after lapse of 1 year, respondent by represented to the respondent
Mrs.
three.
Haiwala,
I'm sorry.
Mrs. Haiwala. You see, ultimately, long and short of it is that the notifications were made. And after that, the award was there.
Yes.
You are trying to say that in the award,
Yes.
3 people names have been included illegally.
Not only that, my lord. My lord, here, this code has my lord, the left. Then again, my lord, it granted my lord time to acquire it. My lord, they issued a notification number 741 along with a 17.4, which is illegal, my lord, on the face of it. That I am challenging.
Along with
17.4. No, 17.4 is not applicable so far this land is concerned. They say that Western Urban land. It is not a Western Urban land. And how 17.4 can be, my lord, where it can be applied? I shall place, my lord, the judgments also on this regard. And this is not a Western Urban land.
Seventeen four.
17.4. Yes. Special provision in case of urgency, my lord.
Yes.
In case of land which is opinion of the separate government, provisions of subsection 1, subsection 2 are applicable. The applicable government may direct the provisions of section 5A shall not apply, and it shall direct declaration is made under section 6 in respect of the land at any time, and that the date of publication of the notification under section 1.
My lord, my right is highway, my right is there, my lord. That right cannot be taken away, my lord, so easily, my lord. That you also will see that notification, my lord, at page 24. Nothing has been followed, my lord, here. Nothing has been followed.
Yes.
My lord, if your losses come to my lord, and accept, my lord, that notice, notification. Which is a consider notice of section 4 as well as section 7. Prior to that, my lord, your losses may see, my lord, twice it was left, and the annexure 1 is the last judgment, my lord, by which they were granted time, my lord.
Yes.
So they were granted time up to 31/5/13, my lord, to complete the proceeding. And this annexure 2 is the notification. It is hereby notified that land within boundaries so and so with the site below measuring or more or less 3 kata 3 licha, 3 kata 13 lichas. And so village Aporigo Moja Beltra subdivision Guwahati Kamrup metropolitan is needed public purpose for construction of Guwahati Medical College, which is bounded by so and so. The notification is made under section 4(1) of so and so act to whom it may concern. Government may further be pleased to authorize the officers for time being engaged in undertaking will their servants and workmen to enter upon and survey the land and to do all other acts required permitted under subsection 2 of section 4 of that. In exercise of power but this is what I mean. Exercise of powers conferred under section 17 subsection 4 of the project, government have decided that in view of urgency of the project, the provisions of section 5A of the Act shall not apply to waste and arable land. My lord. Now, first my question is this, my lord, this is not a waste and arable land. And where section 17 can be applied, my lord. I'm just placing, my lord. I'm placing some definition of dictionary also as well as the
I am giving the dictionary meaning of the western arable land also. Webster Dictionary, Oxford, as well as Black Law.
Right to fair compensation. Right to fair compensation.
And two judgments of Supreme Court on the judgments of the new Webster Dictionary, my lord, that is arable is there. Land fit or used for growing of crops, a plot of such land. Similarly, Oxford is there, well, same. In Oxford, Westland is also described, my lord. An area of the land cannot be used or that is no longer used for building or growing things thereon.
Yes.
And that Black's Law Dictionary also, my lord, but the arable land has been used. That which is fit for plowing or tillage and thus distinguished from swamp land, that's land to wet for cultivation. Now I am placing two judgments of Supreme Court, madam. First one is my lord, year 1967 Supreme Court 1081.
Wheat will be a crop.
My lord,
Wheat will be a crop.
Wheat.
Wheat.
which will be a crop, but this is not a, this is the building, my lord, this is highland. Medical college, my lord. It is very high, my lord.
No, I'm asking you because in my house I grow
That's another aspect of the matter.
I
my
grow
lord.
wheat grass because at times I consume it.
Yes, that is normal. That is not normal, my lord. My lord, your losses may just see Supreme Court, my lord.
Since I'm a vegetarian, it gives me a lot of
Yes.
What you call minerals from there.
Yes.
Wheat, then
No,
what is the
we
English
thought
of
Teddy, my lord, that otherwise, my lord, that is another aspect of matter. But normal, my lord. That.
yes.
In 67 Supreme Court, my lord, 1081, fell of height, my lord, medicine. At page 1084.
Yes.
On behalf of the appellant, Mr. Iyengar referred to the
Page you are reading where?
fell of height. At page 1084. On behalf of the appellant, Mr. Iyengar referred to the inspection note of the collector dated December so and so at so and so. It was pointed out that the collector noticed that there was 1 lakh of trees in the acquired land and there was the trees of tendu, sun, sin, bijal, bamboo, palum, mahua, kakora contained the area. It was contended that the land in dispute was first land covered by large number of trees and cannot be treated as wasteland for arable land within the section 17(1) or 4 of the act. In our opinion, argument put forward on behalf of the appellant is well founded and must be accepted as correct. And in view of the facts mentioned in the affidavits and in the inspection note of the collector dated so and so, we have the opinion that land sought to be acquired is not waste land or arable land in the meaning of section 17(1) or 4 of the act. According to Oxford Dictionary, arable land is capable of being plowed or fit for tillage. In the context, section 17(1) of the act expression must be construed to mean lands which are mainly used for plowing and for raising crops. And therefore, the land acquired in the case is not arable land. Similarly, the expression wasteland will also not apply as the first land. According to Oxford Dictionary, the expression wasteland is defined as waste, uncultivated, incapable of cultivation, habitation, producing little or no vegetation, barren, desert. And the expression wasteland, as contrasted to arable land, would therefore mean
which is unfit for cultivation or habitation, usually barren land, with little or no vegetation there. It follows therefore that section 17 on act is not acted in the present case, and the state government therefore has no authority to give direction to the collector to take possession of the land under section 71 of the act. In our opinion, the condition imposed under section 71 is the condition upon which the jurisdiction of the state government depends, and it obvious that wrongly describing the question as to the character of the land by the state government cannot give itself jurisdiction to give a direction to the collector to take possession of the land under section 71 of the act. It is established that where the jurisdiction of an administrative authority depends upon a preliminary finding of the fact, High Court is entitled to the proceeding in the writs of surgery to determine upon its independent judgment whether or not the finding is correct. See so and so, committee so and so. We are accordingly of the opinion that the direction of the state government under section 17 on the act of the collector taking possession of land under section subsection 1 is under practice. Well, here they have mentioned that they have already constructed some house, my lord, after requisitioning the land. That is the facts, my lord. That is why I want to place the my lord. Then another judgment is there, my lord, that is 68 Supreme Court 870.
Where is that statement?
Yes,
Land is constructed, the house is constructed.
yes, my lord. Okay, yeah, I'm just. My lord, if you will also see the affidavit of wisdom.
Yes, of,
Paragraph 4.
no, of,
Affidavit of wisdom of respondent 5 and 6.
5, 6, yes.
Yes. Yes, madam. Not here, not here, my lord. I'm somewhere in here. My lord, in the judgment itself is there, my lord, they have mentioned it. If you also see, my lord, annexure 1, annexure 1, page 22, my lord, the last paragraph.
Yes,
In the counter affidavit filed by respondent 6, it has been stated that steps have been taken towards acquiring that. It has also stated that land in question is under occupation of the regional dental college of construction of two-story RCC building in the middle of the land. Then again, my lord, court has said, considering the matter in its entirety, next page, in view of the fact that regional dental college is located in the said land, the same is under occupation residence in nature. So they have already made a construction. Now, my lord, I am placing the 68 Supreme Court 817. Here, my lord, from paragraph 18 onwards.
Actually, you have to answer the question.
My lord.
If according to what I've read, since 81, the land is in their possession. So why should be reverted back to you?
Oh, that is another aspect of the matter, my lord. Now, my lord, suppose this posting go, they have to acquire it under 2013 Act, my lord.
No, this was completed before this notification was issued.
Yes,
Prior to the new act came into force.
prior to new act, but they have arbitrarily, my lord, issued under section 74. That is what I am challenging, my lord. In usual course, they could have taken, my lord, that is another aspect. That they have not taken. That's, as per report also, well, poison has been taken, so they have to fix the compensation under new act, my lord. And this is a my lord detailed judgment, my lord, here. Regarding question I will learn 68 Supreme Court.
No, but you have to also explain this acquisition took place in March
My lord?
2013.
Huh.
March 2013, the acquisition took place.
Huh.
And this challenge is made in January 2014. After
No.
a year.
So we filed the revision in 13, my lord, right?
No. It was filed on 17/10/2014.
Huh. No, this is amended revision, my lord. This is amended.
Is it?
Yes, my lord. The original is there, my lord. This is amended revision affidavit.
Oh, acha. Okay. Okay, I did not notice it.
My lord.
Okay. Yes, 68 Supreme Court.
Yes, my lord. Paragraph 18, my lord. Paragraph 18, this brings to a contention that since the lands in question were under cultivation, they did not constitute waste or arable lands. Because arable means land capable of being plowed or fit for tillage and not actually cultivated. The High Court rejected the contention, disagreeing the decision of the Bombay High Court reported in so and so. Mr. Sen has adopted the judgment of the Bombay High Court as part of the argument. Mr. Gupta in his reply relied upon the so and so, versus so and so, 67 Supreme Court validated. So and so. The reasons given in the judgment under appeal, we shall first deal with the three rulings from the Andhra Pradesh, Allahabad, and Patna High Courts. The first contains no discussion and may not be referred to here. In case of from the Allahabad, reference is made under section 73 of the Act, in which there is a provision for standing crops must be compensated for, and it is inferred that by arable land must be meant only land fit for cultivation, but also actually under cultivation. In case of census. Now, I'm skipping over that, my lord. Now, your losses may come to paragraph 20.
20.
There is no definition of word arable in the original Land Acquisition Act. A local amendment includes garden lands in expression. Now, lands are different kinds of, there is a wasteland, desert land, pastured land, meadow land, grassland, marshy land, hilly land, etc., and arable land. The Oxford Dictionary gives the meaning arable is capable of being plowed and fit for tillage, opposed to pasture land or woodland, and gives the root as albus in Latin. The learned judges have unfortunately not given sufficient attention to the kinds of land and the contrast mentioned in the wasteland comes from Latin word vestula or vestus, empty, desolate, without trees or grass or building. It is always used to contrast vestus with uncultivated or in the place to lay waste. A meadow or the pasture land is this not required now. Paragraph 21. We have given these roots because a great deal depends upon the distinction between the visible in understanding judicial decision in English and Irish court. Land described in a different combination of words such as waste or arable
or arable or pasture or woodland emphasizes the different aspects of the land. In many cases, things from one kind of use to another was held to be waste. It is in this sense the quote on so for the Oxford Dictionary said that conversion of meadow into arable or arable into waste wood is waste, but to roll. It is meadow, sometimes arable and sometimes meadow. Sometimes pasture, then plowing of them is not waste. Generally true that the lessee has no power to change the nature of the things. This demise, he cannot turn the meadow into arable, nor starve. I would make its pasture not dry up ancient pool or so and so. Now it is clearly established by several authorities that plowing meadow land is waste. In grants, land often passes specifically as meadow, pasture, arable, or by other descriptions. Plowing meadow land is also esteemed waste for another account, namely that in ancient meadow, so and so must elapse before restored to the status which is plowing. The land therefore considers the conversion of pasture into arable and privacy injurious to the land and those on the ground. Similarly, observations of the person in so and so of the feature same cannot be led to any conclusion. Arable cannot be led to conclusion that arable land means only land capable of cultivation and not land actually cultivated. Well, that was the consideration here, my lord. Now paragraph 23 is amendment.
23.
23.
Yes.
Which says justice observed that because of the land was not in grass for 20 years, the defendant could not treat it as arable, that is ruled by him. The contrast between the grassland and arable land is thus established and does not rule that arable land does not include actually cultivation. Well, that point was there, whether actual cultivation is there, then whether it will be arable or not. That's the thing. Lastly, also that says, my lord, it is under cultivation. So that is what my lord dictionary also says arable means before fit to cultivation. Now, my lord, I shall come to some other judgment, my lord. On section 17, my lord. There's two judgment, my lord. First one is, my lord, 2011 5 SCC 553. I shall place only one paragraph. I shall place only one paragraph. I love
Just one. Yeah, 2011 5 SCC.
Paragraph 77, my lord. At page 602.
Although earlier they have considered all the earlier judgments and they have to come to.
Para
There are 77, 602.
77. Yes.
From the analysis of the relevant statutory provisions and interpretation there by this court in different cases, the following principles can be called out. Eminent domain is the right inherent in every sovereign to take an appropriate property belonging to citizens for public use. To put it differently, sovereign is entitled to reassert its dominion over any portion of the soil of the state, including private property, without its owner consent, provided that such assertion is on account of public agency for public good. The legislations which provide for compulsory acquisition of private property by the state fall in the category of expropriative legislation, and such legislation must be construed strictly. Though in exercise of power of eminent domain, the government can acquire private property for public purpose, it must be remembered that compulsory taking of one's property is a serious matter. If the property belongs to economically disadvantaged segment of the society or people suffering from other handicap, then the court is not only entitled but also we want to scrutinize the action of the state with greater vigilance, care, and circumstance, keeping in view of the fact that landowner is likely to become landless and deprived of only source of his livelihood or shelter. The property of a citizen cannot be acquired by the state or its agencies instrumentally without complying with the mandate of the section 4(5)(a). That is my right, to file objection and to be heard. And 6 of the act. A public purpose, however honorable it may be, does not entitle the state to invoke urgency provisions because the same have the effect of depriving the owner of his right to property without being heard. Only in case of a real urgency, the state can invoke the urgency provisions and dispense with the requirement of hearing the landowner or the interested persons. Section 17(1) reduced Section 17(4) confers extraordinary power upon the state to acquire private property without complying with the mandate of Section 5(a). These provisions can be invoked only when the purpose of acquisition cannot book the delay. This is the important one. Here, they have already taken possession, they have constructed the building their own. There is no question of any offense. They are not book any delay of even a few weeks or months. Therefore, before excluding the application of Section 5(a), the authority concerned must be fully satisfied that time of few weeks or months likely to be taken in conducting the inquiry under Section 5(a) will in all probability frustrate the public purpose for which the land is proposed to be acquired. The satisfaction of the government on the issue of urgency is subjective, but is a condition precedent to exercise the power under Section 71, and the same can be challenged on the ground that the purpose for which the private property is sought to be acquired is not the public purpose at all, or that the exercise of the power is vitiated due to malafide, or that the authorities concerned did not apply their mind to the relevant factors and factors. The exercise of power by the government under Section 71 does not necessarily result in exclusion of Section 5(a) of the Act, in terms of which any person interested in land can file objection and is entitled to be heard in support of his objection. The use of the word may in subsection 4 of Section 14 makes it clear that it merely enables the government to direct the provisions of Section 5(a) would not apply to the cases covered by subsection 1 or 2 of Section 17. In other words, invoking Section 17(4) is a necessary concomitant exercise of power under Section 71. The acquisition of land for residential, commercial, industrial, and institutional purpose can be treated as an acquisition for public purposes with the meaning of Section 4, but that by itself does not justify the exercise of power under government under Section 17(1) or 17(4). This paragraph is also important. The court can take judicial notice of the fact that planning, execution, implementation of schemes relating to development of residential, commercial, industrial, or institutional area are usually take few years. Therefore, private property cannot be acquired for such purpose by invoking urgency provision contained in Section 71. In any case, the exclusion of the rule of hodie alteram paratem embodied in subsection 5(a)(1) and 2 is not at all warranted in such matters. If the land is acquired for benefit of private persons, or the court to view the invoking Section 17(1) or 17(4) with suspicion and carefully scrutinize the relevant source. This is what Section 17(4) has been interpreted, my lord. There is another decision, my lord, of the Supreme Court, my lord,
2010, 11 SCC, page 242. Well, from para 16 more I can place. Yes, my lord. Para 16, my lord. Yes. Section 5A confers a right on the person interested in any land which has been notified under section 741 as being needed for public purpose, likely to be needed for public purpose, to object to the acquisition of the land. It provides that the objector shall provide an opportunity of hearing, and after hearing all such objection, after making such further inquiry, the collector may submit his report to the appropriate government along with the recommendation on the objections and the record of the proceeding. Section 6 provides for a declaration intended acquisition is in the mode prescribed thereunder. The declaration made under section 6 is conclusive evidence that the land is needed for public purpose, and after making such declaration, the appropriate government may acquire the land in the matter provided in subsequent provisions. Section 6 prescribes the time limit in which making the such declaration. Section 9 provides a public notice to be given to a collector stating that the government intends to take possession of the land and claims the compensation for all interest in such land is to be made to him. Well, section 9 notice was also not. As per section 11, collector is required to inquire into the objections that may be received from the person interested pursuant to a notice issued under section 9 and determine the award of compensation inter alia by inquiring into the value of the land and respective interests of the persons claiming compensation. Section 11A prescribes the limitation for making the award under section 11. Section 16 provides for taking possession of the land after the collector has made the award under section 11. The special power in case of urgency or unforeseen emergency conferred upon the government under section 17, subsection 1 thereof, provides that in case of urgency, the appropriate government may direct the collector to take possession of any land needed for public purpose on expiration of 15 days from the publication of notice mentioned in section 9, although no award has been made. Subsection 2 confers power on the appropriate government to acquire the immediate possession of the land for the purpose specified therein in case of unforeseen emergency. Subsection 3A of section 17 mandates that before taking possession of a land under subsection 1 or subsection 2, the collector shall tender payment of 80% of compensation estimated by him to the person entitled thereto and pay the said compensation to them unless prevented by contingency under section 31(2), subsection 4, and cause the government to direct the provisions of section 5A shall not apply on it. Satisfaction and the provisions contained in subsection 1 or subsection 2 are applicable, and the declaration is made under subsection 6 after publication of notification under section 4. In so far as Uttar Pradesh is concerned, subsection 1 has been inserted after 17(1), which provides power to take possession of the land under section 1 may be exercised entirely if the land is required or land development. Section 48 gives liberty to the government to withdraw the acquisition of the land. The matter involves invocation of urgency clause and dispensation of the inquiry under section 5A has come for consideration before this court from time to time. In Raja Anand Brahmasa, so and so this court observed that opinion of the government formed under section 74 of the Act can be challenged ultra vires in the court of law if it could be shown that government has never applied its mind to the matter or that action of the government is nullified. In Jagaram so and so Haryana, while considering the urgency provision so and so, the court found that there was some laxity at the earlier stage cannot be inferred that date of notification was issued. There is no urgency. So held that conclusion. The three judges mentioned in Narayan Govind versus State of Maharashtra extensively considered section 17 vis-a-vis extent of judicial review. That was a case where public purpose
recited in the notification for development and utilization of the said land as residential industrial area. The court stated the legal position as follows. We think section 17(4) cannot be read in isolation from section 4(1) and 5(a) of the Act. The immediate purpose of the notification under section 17, under section 4(1) of the Act is to enable those who may have objection to make laws for the purpose of an inquiry under section 5 of the Act. It is true that although only 30 days from the date of notification under section 4 are given for filing these objections under section 5(a) of the Act, yet sometimes proceedings under section 5(a) are duly prolonged. But considering the nature of objections which are capable of being successfully taken under section 5(a), it is difficult to see why summary inquiry would not be concluded quite expeditiously. In view of the authorities of this court, the existence of such a primary public purpose, such as one present in the cases before us, cannot be successfully challenged at all by objectors. It is rare to find a case in which objections to the validity of the public purpose of an acquisition can even be stated in the form in which challenge could succeed. Indeed, questions relating to validity of the notification on the ground of mala fide that do not seem to us be ordinarily open in summary inquiry under section 5(a) of the Act. Hence, there seems to be little difficulty in completing the inquiries contemplated under section 5(a) of the Act very especially. Now, for the purpose of section 17(4) of the Act, obviously, not merely to confine and under it waste or arable land, but also the situation in which inquiry under section 5(a) will serve no useful purpose or for some overriding reason. Well, this is also necessary. It should be dispensed with. The mind of the officer or the authority concerned has to be applied to the question whether there is an urgency of such nature that even summary proceeding under section 5(a) of the Act should be eliminated. It is not just existence of an urgency, but it needs to dispense with an inquiry under section 5(a), which has to be considered. Section 17(2) deals with a case in which inquiry under section 5(a) of the Act would not possibly serve any useful purpose. Sudden change of the course of a lever would leave no option, but essential communication have to be maintained. If the result is more or less indicating but an operational or natural physical forces beyond human control, what length should be urgently taken possession of. Hence, it offers no difficulty in applying section 74 in public interest, and particular of which obviously to be done in public interest need not be concealed when its validity question in court of justice. Other cases may raise questions involving consideration of facts which are especially within the knowledge of the authorities concerned, and if they do not discharge special burden imposed under section 106 of the Evidence Act without even disclosing a sufficient reason for the abstention from the disclosure, that they have to take consequences which prove from the non-production of the best evidence which could be produced on behalf of the state if the state was correct. In the case before us, the public purpose indicated is the development of an area for industrial or residential purpose. Thus, in itself, on the face of it, does not call for such an action, barring exceptional circumstances as to make immediate provision without holding a summary inquiry under section 5(a) of the Act in imperative. On the other hand, such scheme generally takes sufficient period of time to enable at least a summary inquiry under section 5(a) of the Act to be completed without any impediment whatsoever to execution by scheme. Therefore, the very statement of public purpose for which land is acquired indicating absence of urgency on apparent facts of the case as required eliminated inquiry under section 5(a) of the Act. Again, the uniform and set of recital of the formula like a ritual or mantra apparently applied mechanically to every case itself indicated that the mind of the commissioner concerned was only applied to the question whether land was waste or arable or whether its acquisition is urgently needed. Nothing beyond that seems to have been considered. The recital itself shows that mind of the commissioner was not applied at all to the question whether the urgency is of such nature as to require elimination of the inquiry under section 5(a) of the Act. If it was, at least the notification gave no linking of it at all. On the other hand, its literal meaning was that nothing beyond matters stated to be considered. All the schemes relating to development of industrial and residential areas must be urgent in case context of the country's need for increased production and more residential economy. Yet, the very nature of such schemes of development does not appear to be demand such an emergent action to eliminate the summary inquiry under section 5 of the Act. There is no indication whatsoever in the affidavit filed on behalf of the state
that the mind of the commissioner was applied at all, but question whether in case of necessitating the elimination of inquiry under section 5 of the Act. The recitals in the notification, on the other hand, indicate the elimination of the inquiry under section 5A was treated as an automatic consequence of the opinion formed on the other matter. The recital does not say at all any opinion formed on the need to dispense to the inquiry under section 5A of the Act. It's certainly a case in which recital was at least defective. Burden therefore rested upon the state to remove the defect if possible, by evidence to show that exceptional circumstances which necessitate the elimination of inquiry under section 5 of the Act and the mind of the commissioner was applied to essential question. It seems to us the High Court correctly applied the provision of section 106 of the Evidence Act to place the burden on state to prove those special circumstances, although it also appears to us that High Court was not quite correct in stating its view in such a manner to make it appear that some part of initial burden on the petitioner under section 101, 102 of the Evidence Act has displaced the failure of the state to discharge its duty under section 106. The correct way of putting it would have been the failure of the state to produce the evidence on the facts of the case. Now 25, my lord. In the state of Punjab and so and so, while dealing with the enforcement of section 70 of the Act for public purpose, namely grain market, this court stated that compulsory taking of a man's property is a serious matter, and the smaller the man, more serious the matter. This court observed that hearing the owner before depriving is both reasonable and preemptive of the arbitrariness and denial of the administrative fairness is constitutional anathema, except for good reasons. It was further observed that save in real urgency, where public interest does not book even the minimum time needed to give a hearing on land acquisition authority, should not have regard to Article 14 and 19, work and inquiry under section 74 of the Act. But the other things are there, my lord. I'm just coming to paragraph 41 to 51. All other discussions are there, my lord, on the section 17.
Paragraph 40.
41.
Yes.
The power of eminent domain being inherent in the government is exercisable in public interest, general welfare, and public purpose. The acquisition of private property by the state in public interest or for public purpose is nothing but enforcement of the right of eminent domain. In India, the Act provides directly for acquisition of the particular property for public purpose. Though right to property is no longer fundamental, right under Article 30A of the Constitution mandates that no person shall be deprived of his property save by authority of law. Section 5 of the confers valuable right to an individual is beyond any doubt. As a matter of fact, this court time and again reiterated that section 5 confers an important right in favor of a person whose land is sought to be acquired. When the government proceeds for compulsory acquisition of particular property for public purpose, the only right the owner of the person interested in the property has is to submit objections within the prescribed time under section 5 of the Act and persuade the state authorities to drop the acquisition. Section 5 of the particular land by setting forth the reasons such as unsuitability of the land for the state or public purpose, grave hardship that may be caused to him by expropriation, availability of alternative land for achieving public purpose, etc. Moreover, the right conferred on the owner or the person interested to file objection of the proposed acquisition is not only an important and valuable right, but also makes the provision for compulsory acquisition just and in conformity with the fundamental principles of natural justice. The exceptional and extraordinary power of doing away with an inquiry under section 5 of the Act in a case where possession of the land is required urgently or in an unforeseen emergency is provided in section 17 of the Act. Such power is not a routine power, and save circumstances warranting immediate possession, it should not be lightly invoked. The guideline is built in section 17 itself for exercise of exceptional power in dispensing the inquiry under section 5A. Exceptional the power, the more circumspect the government must be in its exercise. The government has obviously therefore has to apply its mind before it dispenses the inquiry under section 5A on the aspect whether the urgency of the such a nature that justifies elimination of such summary inquiry under section 5A. A repetition by strictly placed in the notification that the state government is satisfied that the land is specified urgently needed and provisions contained in section 5 shall not apply, though may initially raise a presumption in favor of the government that pre-requisite conditions for exercise of power is satisfied, but presumption may be displaced by circumstances themselves having no reasonable nexus with the purpose for which power has been exercised. Upon challenge being made to use the power under section 17, the government must produce appropriate material before the court that the opinion for dispensing with the inquiry under section 5A has been formed by the government after due application of mind and material placed before it. It is true that power conferred by the government under section 17 for administrative and its opinion is entitled to due weight, but in a case where opinion is formed regarding urgency based on consideration not germane to the purpose, judicial review administrative action may be necessary. In the circumstance power emergency can be invoked are specified in section 17(2), but circumstances necessitating invocation of urgency under section 71 are not stated in the provision itself. Generally speaking, development of an area or a planned development of a city takes many years, if it decades. Therefore, there is no reason why summary inquiry as contemplated under section 5A may not be held, and objections or the landowner's person interested may not be considered. In many cases, the general assumption like delay in completion of the inquiry under section 5A is set up as a reason for invocation of extraordinary power in dispensing with the inquiry. Under section 5A inquiry, little realizing that an important valuable right of the person interested in the land being taken away, with some effort inquiry could always be completed expeditiously. The special provision has been made in section 17 to eliminate inquiry under section 5A is deserving in case of real urgency. The government has to apply its mind on that aspect of the urgency is of such nature that necessitates dispensation of inquiry under section 5A. We have already noticed a few decisions of this court. There is a conflict of view. The two decisions of the court in Narayan and Supreme Court. The decision Pista Devi must be confined the facts of those situations in those days when it was entered and two judges bench would not have been laid down a proposed contrary decision. As regards the issue whether pre-notification or post-notification delay to render the invocation of urgency or void, again, the case law is not consistent. The view of the court is different on the suspect due to different situations prevailing in those cases. In our opinion, the delay will have material bearing on the question of invocation of urgency power, particularly in a situation where the material has been placed by the private government before the court, justifying the urgency was of such nature necessitating elimination of inquiry under section 5A. In a country as big as ours, a roof over the head is a distant dream for a large number of people. The urban development continues to be haphazard. There is no doubt that planned development and housing are the matters of priority in the developing nation. The question as to whether, in all cases of a planned development of a city or for the purpose of development of residence area, power of urgency may be invoked by the government, and even where such power is invoked, should inquiry contemplated under section 5A distance with is invariable. We do not think so. Whether planned development of city or development residence area cannot book the delay for a few months to complete the inquiry under section 5A. In our opinion, ordinary it can. The government must therefore do balancing act and result to special power of urgency under section 17 of the Acquisition Act for the public purpose, plain develop city. The use of the power by the government under section 17 and so it's a similar thing my lord is going on. Now in the 55 my lord that last day they have given. In the facts of the case, my lord, they found my lord. In the facts of the case, therefore, government has completely failed to justify the distance for inquiry under section 5A by invoking clause section 74. What is reason the improved notification to extend is that 5A shall not apply to legal validity. The question then rises whether at distance time the acquisition proceeding must be declared invalid and illegal. Here, my lord,
This is the only point.
my lord,
This is the only point.
this is the main point. My lord, moreover, section 9 also not given, my lord. That I was taken special. Section 9 notice to be given, my lord, that extension of compensation also, my lord, we have to give notice that we are going to finish the compensation, we have to make claim, my lord. Yeah.
9 is only a notice.
Yes, notice. That notice has not been given, but that is also important, my lord, because suppose after declaration of section 6, my lord, they want to fix the compensation, then we can make the claim also, my lord. Because that is to be considered while fixing the compensation under section 11, my lord. If you also see section 11, my lord, that section notice 9 has been given. Because at that time, because we can file our, well, that this should be a compensation. So that is also important. For the owner. So my humble submission that, my lord, this proceeding, my lord, which has been taken, my lord, under invoking section 1744 is bad, my lord.
But you have already accepted the compensation.
My lord.
But you have already accepted.
No, accepted without prejudice, my lord, because my daughter's marriage was there. We approached the court, my lord, that order is there. 8/12/2014, my lord. That order is there.
8/12/2014.
Yes.
You're taken with permission of the court.
Yes. Court allowed us, my lord, without prejudice. And my lord, and I can place, my lord, there are judgments, my lord, I should place, my lord, that because yes, so indoor development authority, my lord, that I judgment that, my lord, I'm not placing that only the main portion is quoted here 23(1) SCC 170. That's your lordship.
This indoor development will not apply because here.
My lord, no. Partially at development. Only thing, my lord, position isn't it? Only thing they have taken the position. But I am challenging it on the ground of, my lord, section 74. In para 3, my lord, that has been quoted without, my lord, placing the big judgment. This is the 365 and 66. 366, my lord.
Here, what is the date when the award was made?
My lord.
What is the date when award
Yes, my
level
lord.
was made?
Just give me.
That is 31/11/13, page 27.
Yes. Yes.
So therefore, this 366 paragraph will also not apply
No.
in your case. Yes.
Only thing, my lord, what I am submitting, even if, my lord, it's that side, my lord, even if they wanted to acquire it, they can acquire it. And this, the compensation which has been paid to us, that will be another, it is a compensation because our division manager civil bench has held it in such cases where, my lord, is done, my lord, and that can be adjusted later on. For that reason, my lord, I shall place 2 judgments of our high court. Assam Industrial. Assam Industrial.
Yes.
Just time.
No. You have to put yourself to voting. Who will argue first? No.
Requiring department is Mr. Gogoi. The two judgments are only for the purpose that, my lord, suppose this is side, and even if they acquire it, this will be taken as auto compensation, my lord, that will be adjusted. That's important.
Yes.
May it please your lordship, my lord, I find one affidavit in opposition, my lord, filed on behalf of the respondent number 6. My lord may be pleased to take up the affidavit in opposition,
5 and 6 are together, I think.
my lord.
Yes, 5 and 6.
Jointly by 5 and 6.
5 and oh, 6 also given that. apparently.
6 is the additional deputy commissioner.
No, I don't know, because I just see it is 5 and 6.
My lord, here in this affidavit, the second file I am holding, my lord, it is an affidavit in opposition and
Affidavit of opposition by respondent of 5 and 6
my lord.
by one Srimati Varnali Deka.
Normally, my lord, yes,
Another one is, I'll my lord, is appeared
yes.
on 11/8/15 by respondent 6, my lord. One Chinmoy Prakash Pukon.
One affidavit that is dated, my lord, 13 August 2015, that has been filed by respondent 6.
Filed when?
My lord, that affidavit, my lord, filed on 13th of August 2015. That should be, my lord, in A4 size white paper,
Oh, actually,
my lord,
5.
my lord. The earlier affidavit, my lord, it is in, my lord, full scale paper, my lord,
Ah, yes, 95.
my lord.
This is by 6.
This is by 6. If my lord may be pleased to take up the first affidavit, my lord. That is, my lord, filed by Bernali Deka, which my lord has just now referred.
Yes.
If my lord may be pleased to take up this affidavit, my lord, I will be relying on paragraph 4 onwards, my lord, that affidavit filed by Bernali Deka. My lord has just now, yes, my lord, lordship has just now seen it, my lord. That is in legal size Curtis paper, my lord.
No, that I've seen.
My lord.
Yes.
There, if my lord may be pleased to come to paragraph 4. Where it is stated, my lord, that the regarding requisition compensation with effect from so and so, it is stated that the amount had been paid to the petitioner at the rate of 9% interest per annum. The payment for the remaining period from 1/3/2000 onwards is under process. This is important, my lord. Further, the LA proceedings are also completed. The requiring department, that is the Director of Medical Education, has deposited the amount of 1,03,66,000 as land acquisition compensation against land measuring so and so, pata so and so. Accordingly, the award and proceeding have been approved by the government, and the deponent had already served notices by number so and so to the petitioners for receiving the amount of so and so. The aforesaid notices were duly received by the petitioners on 29/5/2013. As such, the question of de-requisition of the land and handing over khas possession of the land to the petitioner does not arise. Then my lord will kindly, my lord, come to paragraph 6.
Lord, I am reading the second subparagraph, paragraph 6. Further, as per order dated 30/11/2010, passed by this honorable court in WPC number so and so. The LA proceeding was started, but the same got lapsed due to non-placement of fund by the requiring department. However, the LA proceedings have again been initiated now, and accordingly, the award and
Mr.
proceeding
Babida,
has
you,
been-
you may not know certain things because that's why I asked this question and Mr. Saiwala clarified.
my lord.
You see, please note
Yes,
that this, the original writ petition was filed on 26/3/2013.
my lord.
You see, this will have bearing.
My lord.
That is why, when Mr. Saiwala was arguing, I first asked about the date,
My
the delay.
my lord.
Now you see, what we are saying is that
My lord.
the notice to serve,
My lord.
just now you have read, was served on was dated 28/5/2013.
My lord.
Before to that, this writ petition came on record.
Yes, my lord. My lord, what I am trying to, my lord, impress upon my lord is that, my lord, pursuant to this award, my lord, they had challenged the quantum. And my lord, they might have challenged the quantum, therefore, my lord, two LA appeals have been, my lord, registered. And my lord, the amount in question has been disbursed in terms of the money execution cases. That, my lord, will find, my lord, in the later paragraphs of that affidavit, my lord, will kindly come to paragraph 8, my lord. Paragraph 8 of that affidavit, which my lord is just not taking up, my lord. I have violent area card.
Just,
Yes, my lord.
just a moment. No, I'll tell you what has happened. What Mr. Saiwala is arguing is that earlier there was a land acquisition proceeding was initiated that lapsed.
Yes,
And therefore, this is the second land acquisition application. So therefore, the first, this LA appeal, which you are referring to, is at annexure E of that affidavit
yes, my
of
lord.
yours, correct?
Yes, my
There
lord.
is a land acquisition appeal
My lord,
of 1 of 2009.
my lord.
That has got nothing to do with the subsequent land acquisition application.
My lord, yes. Now, if that be so, my lord, then the award,
The sum and substance of argument of Mr. Saiwala in short is
my lord,
that is not against the acquisition. He's not wanting a reversion of the property back.
yes,
What is only his substantive argument is to the effect that it will be now be calculated under the new act because the urgency clause which you had invoked under section 74
74.
was is not sustainable because that was not an arable land or waste land, but you already had this medical college there.
Yes,
Therefore, the urgency for which you have taken over did not exist. And therefore, this was only a eyewash to escape 5A, which required him to be heard. That is the only argument which
Yes,
Mr. Saiwala
yes.
is doing.
my lord, yes. To that
LA
extent,
appeal
my
is
lord,
for requisition, my lord. LA appeal for requisition compensation, not for,
Not for this.
no, requisition compensation.
Oh, acha, okay.
Because this is a from the proceeding of the district judgment, from the reference case.
Okay. In acquisition compensation also, there is a reference made to the district.
No,
judge.
no, no.
No,
No,
but
here-
then, no, you come to page, this running page 53. NHRF page 18. First is that the decree of so and so of the London FTC number 2 in reference case number 12 of 2003.
No, that is also mother same, that is also requisition.
That is also requisition.
Yes.
Oh, acha, okay.
Requisition. That is for interest, my lord, on the delay payment of.
Okay, okay. Okay, when it comes to reference, I always take it is a reference under 18.
No, no, no.
Okay.
Not like that.
Reference for requisition is somewhat rare.
No, I did not know that's why.
Because it is only after culmination of that award, my lord, section 18 is put to.
No. Mrs. Havara is now submitting that the earlier proceedings was not under Land Acquisition Act. It was under the Assam Acquisition and Requisition Act, where you requisitioned the land and rent was not paid.
Yes.
So for redetermination of the rent, the matter went to the district judge for a reference.
My lord,
And
yes.
thereafter, against the reference, there was a land acquisition, this LA appeal. That is what is
Yes,
2009. It's nothing to do with land acquisition. That is what
yes.
Ms. Havara is saying.
Now here, my lord, so far as the invocation of urgency clause is concerned, that precisely is not spelled out, my lord, in the affidavit. That is my difficulty. They only say, my lord, that they had acted as per
But,
law.
you see, it may not be there in the affidavit. It's a question of law.
Yes,
Mr. Savila has supplemented his argument with a constitution bench judgment. Then again, a 3-judge bench judgment of the Supreme Court. And
in the
thereafter,
development.
thereafter the division bench judgment of the Supreme Court saying that urgency clause could not have been invoked when when those urgency is not there. And urgency's example was given there in that one of the cases that it should be flood. That is an example given in that judgment where if, in the case of flood, it could have been invoked. Then you are not required to do it in public interest.
Yes, flood and my lord, there are decisions that for the purpose of sovereignty, if it comes to the question of my lord protecting the sovereignty. My lord, yes, it may be also one of the factor, my lord, parameter.
But if this urgency clause goes, then your entire argument will fail.
Possible, then kindly join me sometime because I have, my lord, we are devoid of the file, my lord, that is the difficulty. I am going by the second file to address my lord on the issue of law, my lord. Because
I can't
ultimately,
keep it parted for long. You can give you time till next Tuesday or Thursday. You have to complete it by then.
next Tuesday, my lord, lots of Thursday. We will reconstruct the file in the meantime, my lord. But then, my lord, at the end of the day, my lord, the quantum of compensation, which the petitioner will be entitled, even if the urgency clause is invoked, but he will not be prejudiced, my lord. They will not be prejudiced.
Means I did not follow you.
My lord, even if the urgency clause is invoked, my lord, and they say, my lord, they have, my lord, set up an argument that urgency clause could not have been invoked, my lord, assuming, my lord. Then, my lord, whether, my lord, for invoking the urgency clause, my lord, whether they will, my lord, the amount of compensation that will be parted to them, whether it will come down, my lord.
No, it's not a question of coming down. It's a question of opportunity of hearing being given.
That is true, my lord. Now, my lord, if it is not done, it is, my lord, not done. I cannot travel beyond the record. But at the end of the day, my lord, since, my lord, his argument is that he is not, my lord, going for reversion of the land. He will be satisfied with the quantum of compensation. That means, if the
No,
quantum
you
of,
see the difficulty in the state, in any what you call institutional setup
my lord,
is that you see once this Transparency Act 2013 comes in, there will be a quantitative jump in the compensation. Now, I don't think any person in your government would like to say take a responsibility that yes, I'll negotiate and I'll do it. that responsibility nobody will take. So ultimately it is that if the law takes its own course, Mr. Sayola get what he deserves. The second, the principal argument you are trying to say is about prejudice. See, there are two ways to look at it. Number one, the state is saying that, well, even if I had given you an opportunity under section 5A, I would not have heard you. Correct. That is one argument. Second argument is that, well, the second argument is that I give you an opportunity of hearing, but I would do what I already intended to do. But still, you see, in both these circumstances, Mr. Sayola gets an opportunity of hearing.
Yeah,
Right of hearing is there,
yes.
and the Supreme Court says that right of hearing is a essential requirement.
It will be an essential requirement, but that's what my lord, I am in some and substance. my
Question
lord,
of prejudice will not come.
my
You
lord,
see, just take this case.
yes,
I am hearing you. I am pretense of hearing I am doing, but I am not hearing you. Correct.
the difficulty is that my lord, now, yes, now if my lord determines the issue, my lord, and my lord holds that, my lord, that we could not have invoked the urgency clause, then the authorities will have to,
Issue a fresh notification if you want to acquire it.
now then majorly it will, if there is a de novo proceeding, right, my lord, is to be initiated, definitely it will. Then, my lord, again, two options are open, my lord. We may go under 2013, because now the scheme is, if we go by, my lord, the state has formulated a scheme. Even if, my lord, in cases of land acquisition under the 1964 Act, but for computing the compensation, the parameters laid down in the 2013 Act are applied. There are notification lordship is ever, I need not trouble your lordship with that. Now, here is a case, my lord, lordship will kindly see the
You
facts.
take
and-
instructions, but then you talk to your people and come back by Tuesday or Thursday when you argue. If your authorities agree to that proposition, you can take it up. Redetermination that can be taken it up.
That, my lord, instruction, my lord, since it is already pleadings are complete here, my lord, now,
No, that is what you are offering.
yes,
So that offer must come.
Yes.
You see, whenever you say anything,
my lord.
that must be backed by some
No, no,
authority.
absolutely, absolutely, correct. But can it be on, my lord, 28th of this month, 220, my lord, then
I can't keep it too long because
I will have some opportunity of, my lord, persuading the authorities, my lord, reconstructing the file. With all.
no, what is
My lord,
no, what is in top of my head is dilapidating fast.
No, my lord, I sincerely apologize for it, my lord, because I cannot, my lord, hold back with the court. But then, my lord,
Make it early. I can't keep it
My lord,
for so long.
yes, my lord, can it be on 15th then, my lord? 15th,
15? Okay.
15th
much I
is
can
Thursday, my lord.
Okay. No issue.
I'm so obliged, my lord. Really, just a-
But if Mrs. Hazarika knows she's sitting behind, if something doesn't happen by tomorrow, I think for next 10 days, you'll not be getting any instructions.
My lord, now, we are taking all efforts, my lord, to bring.
No, not that you can privately speak to her. She knows about it. If something doesn't happen by tomorrow, for next 10 days, you will not be getting any instruction. I can assure you that.
Possible, kindly, my lord, grant me a permission, my lord, to reconstruct the file, my lord, from the second copy, my lord,
That I can't give
my lord.
because it will
Then
be
I will be
contrary
seeking
to.
the assistance of my lord,
No, you can take it from the section, which is what you call from the the certified copies, but by judicially, I can't pass on
yeah,
order to
absolutely.
give you copies.
Lord, I will be seeking the assistance of my lord, the other side, my lord.
Okay, no, there will be no difficulty.
Yes, yes.
Just have a help him.
So,
Lordship, there is a small prayer.
You take his copies and then you photocopy it and return it back to Mr.
I shall
Sarma.
give money.
Huh? Okay. Okay.
So tomorrow I shall give photocopy, Malad.
Okay.
We will get it at our cost, my lord.
I shall give, Malad. No cost is required. No cost is required.
No, no, it is already cost, my lord.
No, it's okay. Mr. Sarma is okay. Listen to some.
I'm so obliged, my lord.
Mr.
Lordship,
Please
there
have a-
is a small prayer, Lordship. Lordship, earlier item number 12 of the dailies to.
No, no, I have not yet completed this. You can't jump in and.
I'm so
in the
sorry.
midst of a
Lordship.
matter. Mr. G. N. Savara, the senior counsel, assisted by Ms.
A. Bhattacharya.
A. Bhattacharya, counsel for the petitioners. Mr. His argument is concluded, reserving right to reply. On the prayer made by Mr. R. Bhattacharya, done it standing counsel for the finance department, revenue department. Is permitted to. This matter will be taken up in the next call on 15, 6/2023 to enable him to argue to make his submission. Mr. K. Gogoi, Leonard, additional senior government advocate. Mr. Gogoi is also there.
Yes, yes.
And Mr. B. Gogoi, standing counsel for the health department are present.
So.
Yes.
Lordship, there is a small prayer. Earlier, item number 12 of the daily list was mentioned by the respondent. And for the petitioner, my lord.
Okay.
My lord, the interim was not continued, my lord. Is the interim?
Item 12. Interim to be extended. Okay.
So obliged, my lord.
But I don't know whether it is, most of the files have already signed. It has been not made online now. Item 12, that is the order is online. It will be first. Yes. Other matters I won't have time to take up.